Lordship, I beg to mention, Lordship, item number 3 is a matter regarding top of the list, Lordship. I play for little accommodation, Lordship. My senior Mr. LP Sharma is not appearing in the court. He is not well. I have also not equipped with the file today. Next hearing day, any hearing day, Lordship. I have to reconstruct the file, Lordship.
Mr. has probably learned counsel for the petition. Has submitted that argument counsel Mr. LP Sharma is not well and he does not have the brief today. As he has reconstructed the file, he has sought for listing of the case on another date. Who is for the Mr.
Finance is there.
S. Roy, Learned Junior Government Advocate of some for the state respondents is present. List the case on. We'll find out a date.
Lordship, Lordship.
Date to silence. Just silence.
My lord, settlement of fishery matter, my lord. And in that case, my lord, already possession has not given to us. Allotment of order has been given to us. In the meantime, they have advertised. One is both the settlement has been cancelled, my lord.
Your settlement has been cancelled.
Cancelled, my lord. We offered the highest rate. Thereafter, allotment order also given, but possession order has not been given. Case is pending and representation to dispose of by the honorable court. But in the meantime, my lord, they have cancelled.
What is the last date of submission of bid in the new advertisement?
But it is not known to me now, my lord, at this stage, my lord.
Monday.
Monday. Yes, lord. But tomorrow, my lord, otherwise, my lord.
May I please, your lordship? Lordship, I beg to mention item number 15. With the consent of the other side, lordship, the matter may be adjourned for today.
15.
Yes, lordship. I am appearing on behalf of the respondents.
MS
G. Swami.
G. Swami Learned Counsel is paying for the respondents. Respondents for listing of the case. After 2 weeks, it is submitted that consent has been taken from the Learned Counsel for the petitioner. Make the prayer. The prayer made by MS so and so is allowed to list the case on after 2 weeks from the date to fixed by the which.
Nice.
Yes, please, your lordship. Lordship, I beg to mention item number 8 and 9 of the daily list, your lordship. The consent of the other side, your lordship, I pray that the matter may be taken up after 2 weeks, your lordship, if possible.
Why?
Lordship, the engaged counsel, Mr. A.K. Gupta, needs some more time to prepare for this matter, your lordship.
A.K. Gupta.
Yes, your lordship. I am not in this case, your lordship. As per his instruction, I am seeking adjournment on.
How many names are there? Mr.
I am KJ Saikya, your lordship, on behalf of Mr. A.K. Gupta.
Your name is?
KJ Saikya, your lordship.
Jesus. Learned Counsel representing Mr. A.K. Gupta. Learned Counsel for the petition. And Mr. Gupta has some personal difficulty and matter be cases be posted after 1 week. It is submitted that consent has been taken. The Learned Counsel for the respondents to make the prayer. Prayer is allowed, leaves the case after a week or a date to fixed by the office.
Deeply obliged.
Please, your lordship. Lordship, beg to mention a matter for urgent listing on Monday, lordship. IMFL launch shop, lordship, at Lanka, Nagaon. So, my lord, there is some urgency in this matter. May kindly taken up on Monday, my lord.
Motion,
Admission, my lord.
admission. Wednesday.
My lord,
Wednesday.
Wednesday. Obliged.
Please, your lordship, I beg to mention urgent listing due to disconnection of electricity connection from my residence, and accordingly I am residing on a rental house. Already there is a standing order of this honorable court to continue the electricity supply during
Old matter,
all
pending.
matters. I have filed IA
Okay,
application.
Monday.
Lordship, kindly today
Monday.
I am residing on the laws.
Reside for 3 more days. Rented house, you're residing.
No, Lordship. Disconnected from my residence, own residence.
Who has disconnected?
APDCL.
APDCL, your own residence.
Yes.
For what reason? Non-payment of dues.
No, Lordship. I had purchased the flat in 2014 from builder but the builder till date not registered, has not given registration. And the APDCL has disconnected and asking to produce NOC from it, builder,
It is a pending matter.
pending matter, Lordship.
Monday.
Lordship, Honorable.
Monday. Okay, this, Mr. Patogi, motion I will take up at after the item number 18. Sorry, item number 17. Let us speak to item number 17 first.
Supplementary list for motion item number 17.
No. Sorry, 18 first.
Item number 18.
Well, before my understand starts below. Will I one small note for the item below? Because there is your lordship, yesterday I went through it. There is no such item in the, which is ISI marked. There is no such item because, my lord, this item is mixture of various items which is manufactured, and the items list are there which are, my lord, are to be given.
Yes.
My lordship, I also see, my lord, the tender which were floated, my lord, by the state of Gujarat at page 1 of the compilation, my lord. At page 6, your lordship can see. Energy dense microson for so and so. The what is to be there, it should be mentioned. Thereafter, each 125 gram dense so and so food should have the following proportion of protein, calories, and so and so. And that is specifically stated. The lordship may also see the next pages, my lord. And thereafter, you also may see, my lord, at page 15. Similarly, page 16 and 17. At page 20, my lord, you'll also find from the Uttar Pradesh. And here also you'll also find in page 22, 23, or 24, all details, what percentage, what proportion should be the vitamin A, vitamin B, vitamin C, everything
Yes.
specifically.
Let us hear Mr. Mazumdar.
And the region, my lord, my mistake, region is that, my lord, like vitamin A, B, C, all proportions are there. Now, in different places, some places, my lord, the shortage of vitamin A is there, some places the vitamin B shortage is there. That proportion has to be given. If assuming vitamin A, B, C, the proportion of one vitamin is more, given in the that may be dangerous. That's why they specify that this used to be the percentage of this one.
Now ISI mark, this manufactured item, there is no ISI mark. The other items which are mixed, maybe ISI mark, but this after manufacturing, whatever items is there is no ISI mark. And the packets also, my lord, on the packets also, it has to be mentioned specifically. I will give one copy, my lord. There is a copy. That what is the contents and how much percentage of this, it is to mention the packet also. You'll also be similar, I will give one copy. She's not here. I'm office में था हमारा स्क्रीन करने
এইফালে কাগজ এইফালে
में साथ ही आया उसको तो आया क्यों सारे से ही आया पहले तो नहीं था it is Hindi below, but every percentage what it contains has to be mentioned. If you also take the last pages, Milord. The last page below, it contains gehu 40%, chini 25%, soybean 50%, chana 10%, mufli 5%, khadya banaspati tel 15%, vitamin and so all. It is mentioned in the cover itself on the packet.
Okay, let us hear.
Mile.
Right, on the three basic issues raised in the writ petition matter, I could not take any instruction because the director is away from Guwahati and he's on the move somewhere. My lord, otherwise, my lord, the bid submission, last date of bid submission has been extended by a notification till 1st of September. And bid opening has been extended to 2nd of September. Lordship may have any date up before that, my lord. In the meantime, I'll obtain the.
Because one thing,
My lord.
first thing that.
Thing is about restricting to the.
First thing, condition to have a registered office in Guwahati.
Man, I have understood. My first is restricting the
Second
competition.
thing is that have
Specification.
required to have experience in state of Assam,
My lord. Both.
right? Thirdly, regarding that
Specification.
temple specification.
These
What
are
I
the-
have found,
Madam.
Mr.
Man, I have
I have
seen,
just checked one, just for your.
my lord. I have seen the rules, man. Now I have read the rules. In
come
the
to
rules, it is
page-
there
Come to page 67.
of the writ petition, my lord.
Yes.
Yeah.
66, paragraph 3, whatever may be protein, calories.
Yes, yes.
that maybe we don't know about that.
Right.
We are not expert on that.
My lord.
Now, after the table, price details,
Yes.
rates are fixed. Now, clause 1,
Yes.
bidder must state clearly whether they are willing to undertake a job as per the terms and conditions because of the entire cost fixation of the work is being governed in adherence to the strict guidelines as laid down by the norms of the government of India, so and so, so and so.
Yes.
Later dated so and so. Then
Category wise.
come to. Just I had a look, I don't know. 162.
Page, my lord.
162.
Page 162, my lord. Yes. And notification.
163,
Yes.
4. Application is there. These rules are. These clause 2. These are Anganwadi, meant for Anganwadi.
Yes.
It has repeal all our earlier rules.
My lordship is saying which page?
Page 162 of the repetition.
Yes. This is a notification of 12th of September 2020
Whatever was existing in 2017,
Earlier.
everything has been repealed,
by this.
right?
Yes.
And this is meant for Anganwadi. Right.
My lord.
Now come to clause 2, next page. This is meant for child 6 months to 6 years and
Lactating mother.
lactating mother. Now, rule 4,
Yes. Nutritional standards.
as per the provisions of the act,
Yes.
right? Then come to previous page,
62 again, my lord.
159.
Yes.
All nutritional standards, whatever was existing in 2017, have been denotified.
Miss, I'm aware of this. I have dealt with
Ah.
this notification earlier in different case.
Ah. No, I have seen whatever privacy
Yeah.
I am indicating to you.
My lord.
Then 153. Standards are set by Government of India.
Yes,
Standards are set by Government of India.
yes.
But question is about the nutritional value, we don't know. So far, these two condition is concerned, it appears to be bit. First two. There are three issues basically. First is having a
guidelines-
registered office.
My lord, these guidelines, I'm not disputing.
Second is having experience.
Yes. My lord,
Because
experience-
why, if Assam standard is much higher, then we could have understood it.
My lord, Lordship is saying that it has to be tested on the envelope of Article 14. Any entity in any way in India, whether she can be restricted or not, that is the issue.
Yes, these
I have
two,
understood.
these two.
And
So far, 1 and 2.
1 and 2.
We
My lord,
don't, we don't know about this nutritional standard, whatever is there. It
Yes.
can be, it requires some
my
examination.
lord, today I have also understood, my lord, that much, my lord, I've now gone through the petition. What I am only paying today is that I could not take any instruction because on this I will also confront them. What is the basis for saying that you are restricting the entire competition of the bidding process within the entities in Assam? Because once you say the registered office has to be in Assam, that means the entity also has to be in Assam.
Yes,
On what basis they are restricting? If they, I do not know what justification they'll give. I'm only paying for that man because we could not interact with.
suppose, for example,
Madam.
Tata is in business, in this business.
Yes,
They want to participate.
they don't have any.
Because of that clause,
They cannot.
they are restricted.
Madam, I have understood that.
That's one
That is a-
example.
This issue is absolutely clear, man, to me. I only want to take their view. What do they want to say? Director is on the move, my lord, over phone. We tried. He cannot be interacted
So
because.
far, first two issues are concerned, it is up to you whether if you come up with some origin them or not,
Some-
it is up to you.
Yes,
That I leave it to you. It
because
is-
ultimately.
So
they-
for third issue is concerned, that is with debate.
Yes. And the idea is to give them the food which is nutrition filled with nutrition. So these small issues we should avoid and ensure and in
If there is a standard benchmark,
then it's different.
then that has to be followed.
My lord,
If the government of India has set a benchmark,
that has to be followed.
that has to be followed.
Yes.
This much I can say.
My lord,
So you
I-
want to say that
my lord, I'm only playing because there
We
is
should-
already a curriculum, they are also aware of it. The bidding, last date of submission has been extended to 1st of September. And opening of bid is fixed on 2nd of September, 5 o'clock in the evening. Before that, Lordship may kindly have a date. In the meantime, I'll get the second. Maybe, my lord, 1 or 2 clause I may consider also. I cannot right now indicate. Because.
no, I am not asking you.
No, no, no,
You
no.
consult. you
My lord,
consult.
yes. One, I'll
Then if
find
you have
out what is
28.
the basis for putting this restriction. If they cannot justify, I'll have to concede.
28.
My lord.
Yes, Dr. Sarah. Since it is extended. And I have expressed my tentative view on the first two issues regarding registered office and having experience in Assam. The third one, we need some more examination. Let him come up with that.
Instead of 28, can it be on 30th? My lord? I've got too many matters in port number 1. There are big matters. My lord.
Follow the subject to your lordship's approval. Let the matter come 30th or something, there is no problem. What is the harm if I submit the tender bid below? Is there any harm below? It will be subject to the result of the expedition.
Right.
So let me submit the bid, they will not finalize it. Because there is no price bid. Let them, 30th, there is no problem, but let me submit it. What is the harm?
My lord,
below?
No, if I mean, that is
My
very
lord,
no bar.
I would have conceded to this pair. My lord, I have not been able to give any response. Let
No,
me
I know,
give some response.
Submitting.
If I cannot
does not mean-
justify, my lord-
Lordship will observe that submitting a bill will not confer in right. But submission of bid, why up to the last day?
No, if required on
Lordship
30th,
can always
I'll
extend.
say that the petitioner will submit his bid and the authority
Yes,
should not insist on this.
yes.
compliance of
No, no,
this.
let us wait till 30th.
So
let us
far-
not be in a hurry.
Food value and we have need some examination.
Well, that will be a final hearing, your lordship.
That, but so far first two clauses concern permitting you and or rejection of your bid on the ground that you do not have registered office. I have some reservation.
Right.
That clause I am
Well,
not very
subject to-
satisfied, and regarding the experience part
Right.
also.
Subject. to-
These two, but
These
so
two
far
are-
this setting, yes, I also do not find any logic tentatively
My lord.
that if the supplier mixes all these nutrients,
My lord.
how can he get ISI mark?
No, that
Because-
is, but
I am
they
just
are-
asking.
but I'm just indicating, they are not objecting to this. They are saying we can do it, but you have to specify. And I have also little bit of research I went
Yes.
yesterday. Possibly, my lord, I will have to take instruction because it says that for this product, some specification may be necessary also. That's what I'm saying. My lordship will give me until 30th. I'll come up with all the
Because the
response.
reason-
And because of 163,
My lord,
rule 4, nutritional standard,
yes,
the detailed
my lord.
standards of nutrition to be supplied to the beneficiaries should be as per the provisions of the act.
Act.
If it is the standard is statutory,
Set, yes. Then there is no question of deviating.
Below, otherwise, the 6 months.
what is the standard?
Well, 6 months baby is there.
No, what is the standard?
Below the
I have not
standards,
gone through act.
different standard for the different, below,
No, this is meant for only this.
no, 6.
3B,
My lord.
kindly see 3B, application. To every pregnant woman and lactating mother till 6 months after childbirth and every child in the age group of 6 months to 6 years, including those suffering from malnutrition.
My lord.
This is clear. This rule is applicable for the beneficiaries which is intended under this tender process. Am I clear?
My lord.
So this is a statutory rule framed under that Food Security Act.
Yes.
Rule 4 says nutritional standard.
My lord.
So tender condition has to meet this condition.
Yes,
My
yes.
lord.
As simple as that. We don't know about the nutritional standard, detailed standards of nutrition.
Because, my lord, the
I
reason,
think you could,
the reason is that, my lord, I must submit, my lord, the chart which has been given, that vitamin A, vitamin D, vitamin C, vitamin D. Now, if the quantity is not mentioned, it says that vitamin so much, that may be very risky.
no, Dr. Saraf, if the nutritional standard, detailed nutritional standard is laid down in their rules, then it is easier for all the parties
Then
to
if it-
follow it
If it,
and to examine that standard with the tender clauses.
so it has to be
That's
said
all.
that it has to be made, the standard. has
We
to-
will not examine 10% or 12% protein.
Exactly. Well, this,
No,
they
your
will
lordship
have
will
to
not
answer.
examine, my lord, your lordship will say that whatever has
They
been
will
laid
have to
down.
answer this.
You will have to also answer.
No, my lord, once it is set in the act itself, in the schedule that this is the standard. Now, whatever is the specification, you will have to meet.
Yes, Mr.
That's
Goel,
still-
do you have the standard?
Anyway, since your lordship is taken up.
For different states, for different states, my lord, it, like 14 may be in some state. it is-
No, detailed standard government of India has laid down.
FSSA Act,
Ah,
FSSA Act 2006, man.
supplied would be as per the provisions of the act. So FS, I think Food Security Act has laid down the norms. That's all.
They will clarify, my lord, that this will be, that will be exactly
So
the same.
Mr. Majumdar, please take instruction on
My
that.
lord, my lord, my lord. I'll come up with all the response. He is not available. We could not interact with him over phone also.
But
He's
subject to,
from
my lord, the
30th, my lord,
30th.
30th.
30th, any date is there.
They will have 2 days time. Lordship may extend also, my lord. There is no difficulty. Once your lordship permits them, if your lordship permits them, they can submit it within first, or if your lordship is required, your lordship may extend.
30th will do.
30th.
Or
Yes.
30th.
No, but what is the 30th, whatever you do, whatever you make
30th.
instructions, but submission.
Because it is
I'll come up with all.
1st of September.
My lord.
Okay.
Enough time is there, my lord.
Mr. Heart Dr. A. Saraf, Narayan, Senior
Well,
Consultant.
I'm fairly conceding, submitting, if I find that any clause is not my lord, meeting the requirements of Article 14, I'll concede
That's why.
I'll try to
that's
convince
why
my client.
yesterday-
instead.
Yesterday, today, my learned friend is considering. That's why my learned friend is also very senior and my lord, my colleague.
That's what I'm saying. my
That's
lord.
why, my lord,
If-
yesterday when
if
you
it-
used the word absurd while my submissions, today So he should be very selective while using the words. There's a submissions as absurd.
Assisted by Mr. A. Goel, learned counsel for petition, Mr. D. Mazumdar, learned additional advocate general Assam, assisted by Mr. MS.
S not.
S. Nath,
Well, let his, name- my lord, let his name go. in the
Mr. M.
public.
Shetty, learned junior government advocate Assam. For the respondents, post of Mr. Mazumdar, learned additional advocate general Assam has submitted that the last date for submission of which in response to the RFP of EOI dated 3/8/2023 has been extended up to 1/9/2023.
And bid opening up to second,
No, ultimately it is a bid submission.
be submission.
Full stop. He has further submitted that he has not been able to obtain instruction raising this rate petition.
Because
And
the director is
he-
out of station.
as a director from a women and child development,
My lord, WC.
Sam
WC.
is out of station. Full stop. He has just sought for listing of the case on 30.
Well, it may be 29th, I agree, but my learned friend will not be there, so 29th. if it was-
No difficulty, no difficulty.
29/8/2023. For enabling him to obtain the instruction, enable him to obtain the necessary instructions.
My lord.
Deeply obliged.
Item number 17.
Yes, Mr. Nayak. Or Mr. Setia, who standing now? DMC. Okay, what are the facts?
So let's start, my lord. My lord, a tender notice was issued, my lord, that on 14/3/23, inviting tender for settlement of 53 parking places, my lord. That a tender notice at page 15, my lord. Right.
Okay. Terms and condition,
Terms and condition at page, my lord, 16, my lord. My lord, relevant clause will be at page 17. D, my lord. After offer, my lord, if the tenderer defaulted, the bidder will be disqualified and his earnest money so deposited in the prescribed form shall be forfeited. In such a situation, the next highest bidder shall then qualified for the next offer.
okay, this default is for what? After receiving the above mentioned documents. A bidder will be given a final order.
The,
C is to be read.
she is to be, after receiving the above mentioned document, the
Balance
bidder will be
given-
given a final order granting the lease of the parking. The balance 50% amount of settled value will have to be deposited by the bidder in two equal installment. The first installment need to be paid within 3 months and second installment need to be within 6 months from the date of the final order. I have to deposit 50% in advance and 50% in two
Oh, no,
installments.
before that, B, I think, B.
B, after getting
After,
the LOL, the selected bidder has to submit an
So
agreement.
you got LOI.
LOI,
Right, okay. So you are required to execute an agreement and to deposit 50% of the settle value.
Settlement.
So you declined.
Decline.
Okay.
I stood highest in two parking slots. In one, I deposited the amount, I got the settlement and operating it. And in one, I declined, my lord.
Any other clause in the tender notice?
No, my lord, there is no other
These
clause.
these three are relevant. Basically, 8 is relevant.
8 is relevant.
This, but what is the parking stand?
Parking stand is, one is HB Road from Khupsan to Sikmondi left side, and one is basement parking of the Fancy Bazaar.
Okay, page 16 is, it is there, Adabari bus terminus. It is same, the conditions are same for all.
Which one, my lord?
Page 16,
16,
kindly see the first two lines.
huh?
Terms and conditions of lease of Adabari bus terminus,
Page 16, my lord.
16. Of the repetition. First two line in bold, heading.
Terms and condition of the lease of Adabari bus terminus for the, no, it's for the,
It is for same or not?
it is for same, my lord.
Rag, it is same?
Same.
Yes, Lordship.
Same. Conditions are same.
Condition are
Okay,
same.
no, there is no doubt. Okay. So you participated in slot number 43
43 and
and Fancy Bazaar basement.
basement parking
Okay. Then letter of intent was issued.
issued, my lord.
Tender notice number so and so be received, pursuant or be submitted against our tender held on so and so. More. First one is page 20.
20, my lord. Yeah, second paragraph is important, my lord. LOI. As per clause 8 of the terms and conditions, you are hereby requested to submit the following document as per due date scheduled below. Failing which this LOI will be stand cancelled.
Okay, now come to 22.
22 is they after deposit my of 50% kids money, settlement value. They settle it, the parking place from Khupsan to Tikmondi parking 43 to me on 8/5/23. So for this parking is,
In pursuance
there
of
was no
said
dispute.
pursuance. So this list has been given to you.
Yes, my lord.
The balance payment with value amounting to rupees 20. Okay. Then
Then so far the parking slot of basement parking, Fancy Bazaar Municipal Market, I declined to accept the offer by my letter dated 10/5/23
page,
at page 24. I am not reading this letter, my lord.
you to some-
English is very high. Page 25, my lord, that order come, my lord. 24/7.
Meter during the tender for the of parking slot placement accordingly for the shoot. Where you have submitted the data proposal. As this practice is becoming very frequent, very does causing loss to the organization under the circumstances for the above mentioned parking as prohibited. You were also registered. Any kind of from the date of issue is solved. That has the appropriate
Then next page, page 26, my lord, order is 48.
in blacklisted. But the most common order of the thing. These for the is referred to parking place when these amount to be adjusted from. Situation the issue of the order and any amount of refunded. Okay. Yes, Mr.
Now they are coming with an affidavit, my lord, wherein they said that they allege that cartelation and manipulation, collusion, as well as they relied for blacklisting under section 11 of the Assam Preferential Store Purchase Act and yes, Public Procurement Act and Rule 20 for cancellation. My lord. The lordship has to go to the section 11 of the Assam Public Procurement Act, my lord. Whether section 11 to 3, Roman 3 is applicable to my case or not. That is page,
Your intention of pollution, cartelization. Cartelization. It should be there. Are you doing it with? As per provision of Rule 31. Oh. The procurement shall take action against the services to be there as per the provisions of the act. And the actor or leader. So they have drawn the conclusion that you are in collusion and you are in a cartel
cartelization. What is cartel?
without serving any kind of notice.
Look, because of they allege it, your lordship has to look into it, what is the cartelization and collision?
No,
Even
we are
the-
not, but whether notice has been served or not, notice, no notice.
No, no, well, even your lordship, they allege it that under 11(2)(3), my lord, your lordship of the act, my lord.
No, otherwise law is such that tendering authority has the inherent power,
Power.
whether in a statute or not in a statute.
Huh.
We are not going into it. Here is a question whether due notice has been served upon you. Or
Apart from that, my lord, under section 5 of the Contract Act, I have a right to withdraw my lord, offer. Because that also accepted by
also,
the,
they have a right to forfeit,
yes,
but other things regarding blacklisting,
ah,
whether this is permissible without serving any kind of notice. That is the issue.
no, that's it.
That is the issue. Yes. Take it easy.
Lordship, 2, 3 conditions I would like to place first, Lordship. Lordship, may kindly look at page 16, Lordship.
Level, more com-
Page 16, Lordship,
Page,
of the repetition. This is the bid document, Lordship, tender conditions.
yes,
Serial number 8, Lordship, selection process. After scrutiny of the documents submitted by the bidders, the successful bidder will be intimated by giving a letter of intent, him, her, after getting the so and so. After Lordship, after receiving the above mentioned document, the bidder will be given a final order granting the lease of parking. The balance 15% amount shall be settled, have to be deposited by the bidder in 2 equal installments. The first installment need to be paid within 3 months and second installment needs to be paid within 6 months from the issue of the. These important, Lordship, on default. The bidder will be disqualified and his earnest money so deposited in the prescribed form shall be forfeited. In such a situation, the next highest bidder shall stand qualified for the next bidder. So this is the first condition, Lordship. Secondly, Lordship, may come to the Assam Public Procurement Act and Rules, Lordship. First one is the Act, Lordship.
act number item person.
I have
Item goal. So the closure that I act. Okay, you have the act.
yes, Lordship. In the Act, Lordship. Lordship, may kindly come to 11, Lordship, 1036, page number.
Yes.
11, Lordship, code of integrity for procuring entity and bidders. No officer or employee of the procuring entity or a person participating in a procurement process shall act in contravention of the code of integrity prescribed by the state government. 2, Lordship, the code of integrity record to subsection 1 shall include provisions for 1 prohibiting prohibiting any offer. Lordship, I am coming to 3, Lordship, Roman 3, any collusion, bid rigging or anti-competitive behavior to impair the transparency, fairness and progress of the procurement process. That is 1. Then I am coming to 3, Lordship.
3.
Yes, Lordship, down below. Without prejudice to the provisions of chapter 4, in case of any breach of code of integrity, above conditions, Lordship, code of integrity by a bidder or a prospective bidder, as the case may be, the procuring entity, after giving a reasonable opportunity of being heard, may take appropriate measures, including A, exclusion of the bidder from the procurement process. C, Lordship, forfeiture of or encashment of any other security or bond relating to procurement, recovery of payments made by the procuring entity, etc. E, cancellation of the relevant contract and recovery of compensation from loss of incurred by the procuring entity. D, debarment of the bidder from participating in future procurements of the procuring entity for a period not exceeding 3 years under section 46, Lordship. Lordship, I can then come to 46, Lordship, that is the provision for debarment from bidding, Lordship. So 2 is there, it is up to 3 years I can debar, Lordship. 46, 2, page 1057.
Yes.
2, Lordship, a bidder debarred under subsection 1 shall not be eligible to participate in a procurement process of any procuring entity for a period of not exceeding 3 years, commencing from the date on which he was debarred. And 3, if a procuring entity finds that the bidder has breached the code of integrity prescribed in terms of section 11, it may debar the bidder for a period not exceeding 3 years. So I'm just placing the law, lordship. Then lordship, if come to rules, lordship. Rule 20. Lordship, this is page 22, lordship.
Yes.
Rule 20, lordship, I'm coming to next page, lordship, page 23, 5. 205, subsection 5, lordship. So notwithstanding anything contained in sub-rule 1 above, a registered bidder who already holds a previous contract or award for works or supply of goods which is in progress is found to have adopted fraudulent means or has otherwise violated the provisions of the Act while submitting bids or undertaking a different work or supply shall be debarred from participating in that bid and in all bids for future works for a period up to 3 years after being given a reasonable opportunity of being heard, but may, if the procuring entity so decides in the public interest, not be deregistered till the completion of the or cancellation of such previous contract or award for works or supply already been. Here also lordship condition says up to 3 years, lordship. And lastly, lordship, at page 100, lordship. It's rule 31, 4. Page 101. Sub-rule 4, lordship. If the bidder whose bid has been accepted fails to sign a written procurement contract or failed to furnish the required performance security within the specified period, the procuring entity shall take action against the successful bidder as per the provisions of the Act or these rules, lordship. So these are the provisions, lordship. Naturally, definitely rule says, lordship, also Act says an opportunity should have been given to the petitioner, lordship, that I'm submitting, lordship. But it appears, lordship, no such opportunity was given to the petitioner, lordship. But so far as other tender condition is concerned, lordship, that forfeiture of the security and that is there.
We are not into forfeiture. You are empowered to
Lordship.
forfeit.
Lordship, I am
But the
entitled.
question is only two things. I am not into that. You do not have the power to blacklist.
Lord.
You have the power to blacklist. But question is that violation of the principle of natural justice, that is reasonable opportunity of being heard. It appears that it is not there. That has, and secondly, blacklisting for indefinite period, where the statute provides 3 years,
Lordship.
right?
Lordship.
On these two conditions, this is not
That is-
sustainable.
So that is
I am
my,
not debarring you to proceed against him. But question is that do not proceed violating the statutory provisions. Your own Act says
yes.
that these two conditions are violated. That is indefinite, one cannot be blacklisted for life. Secondly, that reasonable opportunity must be afforded to him before blacklisting him, because it is civil debt,
Yes, Lord.
right? Because it is not only GMC. He is stopped from doing any business with any other organization
So
for
lordship-
life.
Lordship, that is.
You meet the requirement.
So lordship, I'm on record, lordship, I'm.
No,
sitting
I am
there.
not recording.
But lordship, what I'm praying, lord,
I'll
Lordship will-
record whatever is stated in the
Yes.
affidavit.
yes. So lordship will give me some time, lordship, within which a notice. will
No,
be
it is
served
up to you.
him, Lordship,
It is up to
Lordship
you.
will-
I will not.
but
I'll
I'm only
test this.
praying, lordship, till that moment, lordship, the status quo be remain, lordship.
No, this cannot sustain.
So far as the
This
cancellation,
24 cannot sustain, and 25 cannot sustain, and 26 is based on 25. That also cannot sustain. Hey,
no, I'm. Now, so far as that cancellation part is concerned, lordship, cancellation of the existing contract work, lordship.
No, so far this page 25,
Yes,
the so far as the action as regards blacklisting is concerned,
yes.
That is to be said.
Second one is there, Lord. Second one,
then
Lordship.
this,
Lordship, in the first one, Lordship, I'm.
this, you have see paragraph, you have been blacklisted. If blacklist does not survive, this does not survive.
No, that is the second part, Lordship. First part, Lordship,
Which part?
in that order, Lordship. Whereas you were selected as a H1 bidder during the tender of for the lease of parking slot at basement Fancy Bazaar. And accordingly, a LOI was issued by this establishment by memo number so and so. And whereas you had submitted a letter dated, that is a withdrawal letter. And whereas this kind of practice is becoming very frequent nowadays, thus causing financial loss to them. Therefore, under the above circumstances, your EMD for the above mentioned parking stand, that is there, that will remain, Lordship. So
That will
that's
remain.
standard condition. And you are also blacklisted,
Does debarred from
Does
participating
but from participating
in
kind
any kind of tender process under GMC from the date of issue, that is indefinite.
of Lordship.
Where the act, you have just read the provisions, up maximum up to 3 years.
3 years.
In the act also, in the rules also.
Yes. So that for debarring for 3 years, Lordship,
And-
what I am submitting, Lordship,
Ah.
Lordship will give me the liberty to issue him a notice, Lordship,
But
till that matter is decided, Lordship.
No.
Let this remain.
This,
Lordship.
on the apparent on the face of the record. This clearly, have you mentioned anything that you have served notices?
no,
Yes,
No.
because Lordship, that
notice.
second parking was cancelled on the basis of this order.
Uh-huh. One is dependent on the previous one.
Yes, no, as that work has already been taken over from him, Lordship. Now we are managing it of our own, Lordship. So at least till then, Lordship, within 10-20 days, Lordship will decide the issue.
One is not sustained, is not sustainable.
can I
First, you
claim,
qualify on, because he did not commit any misconduct in the second thing,
Lordship.
second
that is
contract.
because.
But
of
he
this blacklist.
committed mischief
Yes.
in respect of first, in the sense that he withdrew. Now, whatever allegation, collusion, cartelization, all these things, you have to put him on notice for that.
Yes, that is.
Am I clear? I am not against you taking action against him. I am again only on it that the procedural requirements are not fulfilled. Am I clear?
Yes.
Only that thing, reasonable opportunity and indefinite blacklisting. Only that.
I leave it to you.
But it is, you have the law is settled. I do not have to repeat it.
Mhm.
Tendering authority has inherent power to do blacklisting, but to do blacklisting, it has to follow the principles of natural justice and affording fair opportunity.
Lordship, Lord, I leave.
Right? I'm not
Yes.
going to that aspect.
That is against me.
You, it is your discretion. It is your wise sense. We do not have to comment on it, whether you will go for against him or not. You discuss and take
Just
action.
one observation, Lordship. It
You do
will,
not have to make any observation. That is,
Lordship, I leave.
that will give,
Please-
even though.
please take your seat.
No, I'll just clarify, below section 26(4), your lordship, can I have a look on it? If I refuse to accept it, what they can do? This is not a offense, my lord, as per the act itself. Has your lordship got it?
26 4 page.
Page number 1043. Act, in the act, my lord. Has your lordship got it? If the bidder whose bid has been accepted as successful fail to sign any written procurement contract as required or fail to provide any required security for the performance of it, the procuring authority entity may cancel the procurement process after forfeiting the bid security provided by the.
That we have done. We have to pull it.
Act provide that below the. And then
The. It is. Mr. Kotoki, come to page 12.
12, my lord.
Okay, okay, now. By. By the instant repetition. Comma preferred under article 26 of the Constitution by the petitioner has assailed an order bearing number so dated 24/7/2023, page 25. And an order dated bearing number so dated 4/8/2023, page 26. Issued under the hand of the Joint Commissioner from Guwahati Municipal Corporation. By the order dated 24/7/2023, comma, the respondent Guwahati Municipal Corporation within bracket CMC had forfeited the earnest money deposit given by the petitioner for the purpose of participating in the tender process for lease of parking slot at basement. Full stop. By the state order, comma, the petitioner has also been blacklisted, comma, thereby, comma, debarring him from participating in any kind of tender stroke auction process under the GMC from the date of issuance of the said order. Full stop. The order dated 4/8/2023 was in continuation of the order dated 24/7/2023. And by the order dated 4/8/2023, comma, the lease of parking slot number 43, comma, HB Road, comma, from Kupchan Point to Sikh Temple Point, Fancy Bazaar, comma, earlier granted to the petitioner, comma, had been terminated with immediate effect. Full stop. The brief narration of facts. which had led to the passing of the aforementioned two orders can be expedited at this stage alone. By a tender notice under memo number page 15 dated 14/3/2023 issued under the hand of the Joint Commissioner, GMC, sealed tenders in prescribed format were invited for settlement of 53 parking places within the GMC areas for the year 2023-2024, that is, for a period of 12 months, WEF 01/04/2023 to 31/3/2024. Full stop. The last date of submission of bid was up to 2 p.m., 5/4/2023. And the tender box was to be opened at 11 a.m., 6/4/2023. In response to the tender notice dated 14/3/2023, the petitioner submitted his bids in respect of 2 parking places. 1, parking slot number 43, HB Road, from Kupchan Point to Sikh Temple Point, left side parallel parking, Fancy Bazaar. And 2, parking slot at basement parking, basement parking at Fancy Bazaar Market Complex. Post. Para. Upon evaluation of the tenders for the parking slots, the respondents GMC authorities had found that the petitioner had emerged as the successful bidder within bracket H1 in respect of the aforementioned parking places. Post. By a letter of intent dated 3/5/2023, a letter of intent, a bearing number page 20, was issued to the petitioner, informing him that his offer, parking slot number 1 for you, parking place number 1, 2 for you. His offer for parking place number 1 had been accepted. Full stop. The LOI had by the LOI, the petitioner was requested to submit the following documents as per due date stroke schedule. In respect of the parking place number 2, as the petitioner had also emerged as the successful bidder H1, another letter of intent bearing number so and so was issued to the petitioner in respect of parking place number 2, containing similar terms and conditions as in the LOI dated 3/5/2023 issued in respect of parking place number 1. Full stop. The petitioner in response to the LOI bearing number page 20, 3/5/2023, the petitioner completed the requisite formalities, including deposit of the amount as asked for by the LOI. Full stop. And accordingly, the respondent GMC authorities had issued an order granting lease of parking place number 1 wide letter number so and so dated 9/5/2023, page 22. Full stop. Para. Subsequent to the order granting lease of parking place number 1 wide on 9/5/2023, the petitioner intimated the commissioner GMC by letter dated 10/5/2023 that due to his financial problems, he would not be able to accept the lease in respect of the parking place number 2. Para. It was in the above fact situation, the order is 25 number so dated 24/7/2023 came to be issued, whereby, firstly, the earnest money deposit given by the petitioner in respect of parking place number 2 had been forfeited, semicolon, and secondly, the petitioner had been blacklisted, thereby debarring him from participating in any kind of tender stroke auction process under the GMC from the date of issuance of the said order. Full stop. The order number so and so dated 24/7/2022, page 24, was followed by the order bearing number so and so dated 4/8/2023, page 26. Whereby no followed so and so, whereby the lease, the grant of lease in respect of parking place number 1 has been terminated with immediate effect. Also, I have heard Mr. S. Kotoki, learned counsel for the petitioner, and Mr. P. Nayak, learned standing counsel GMC, for both the respondents. Mr. Kotoki, learned counsel for the petition, has referred to clause 8 of the terms and conditions of lease issued by the GMC, to contend that in the event the selected bidder did not did not accept the conditions, fails to adhere to the conditions given in the LOI, then such default would only incur disqualification of the selected bidder in respect of the tender in which he participated, and there would be, and the same would entail forfeiture of the selected bidders' earnest money. Full stop. Clause 8 has clearly stipulated that in the event the selected bidder did not accept the offer, the next higher bidder would the next higher bidder would be offered would be given the offer for settlement. Full stop. Assailing that part of the impugn order dated 24/7/2023, whereby the petitioner has been blacklisted, Mr. Kotoki has submitted that the order of blacklisting has suffered from on 2 counts. Firstly, no opportunity of hearing has been afforded to the petitioner prior to such blacklisting. And secondly, the order of blacklisting is for an indefinite period. Full stop. As the foundation, as a basis of passing the order dated 4/8/2023 is the order of blacklisting only, the same is not sustainable as the order of blacklisting itself is not sustainable. Full stop. Mr. Nayak, learned explaining also. GMC has contended that the orders dated 24/7/2023 and dated 4/8/2023 were passed after as it was demonstrated from the act of the petitioner that he had withdrawn from the tender process after issuance of the LOI for parking place number 2. As an act of collusive practice, and the same and the act of such act of withdrawal from the tender process was found to be in breach of the Code of Integrity for Procuring Entity and Bidders as contained in Section 11 of the Assam Public Procurement Act 2017. Full stop. He has referred to the provisions of section. He has also referred to the provisions contained in Section 11 of the Assam Public Procurement Act 2017 to buttress his point that it is open for the procuring entity stroke tendering authority to appropriate measures against an erring, ERRING bidder, including his exclusion from the procurement process and his debarment from participation in future procurement of the procuring entity stroke tendering authority for He has also referred to the provisions contained in Section 46 of the Assam Sewage Act. He He has contended that such kind of practice, as had been done by the petitioner, are are found are found in the tender processes by the respondent GMC authorities. Full stop. As a result of withdrawal of the bid by the petitioner, the respondent GMC authorities had to suffer financial loss to the tune of 2,59,000 minus 1,05,000 within bracket EMD deposited by the petition, as the bid value offered by the H2 bidder was only 29,55,000. Yes, everyone? I have given. Due consideration. I have given due consideration to the submissions of the learning council part of parties, and I have also perused the materials brought on record. Full stop. There is no dispute as regards issuance of the tender notice and emergence of the petitioner as the successful bidder within bracket H1 in respect of parking place number 1 and parking place number 2, and the issuance of the LOI by the respondent GMC authorities in his favor for both the parking places on 3/5/2023. Full stop. The terms and conditions of lease for the year 2023 to 2024 contained the following condition. Entirely contained the following condition, page 16, clause 8, A to A. From clause 8, it is discernible that after issuance of the LOI, the selected bidder had to submit an agreement and to deposit 50% of the settled value as advance deposit within the stipulated time period to be mentioned in the LOI. So it was after compliance of the conditions set forth in the LOI, the selected bidder was to be given the final order granting the lease of the parking place. Full stop. In case the successful selected bidder stroke LOI holder commits any default, the same would incur disqualification and forfeiture and would entail forfeiture of the earnest money deposit given by the successful bidder stroke LOI holder at the time of submitting his bid. Poster. The conditions, the said clause has further mentioned that in the event of default by the successful bidder stroke LOI holder, the next highest bidder would qualify with his offer. Poster. Clause 13 of the tender notice further mentioned that any bidder who withdrew his tender after submission of the tender but before opening of the same then it would be open for the GMC without prejudice to any other right or remedy to forfeit the earnest money deposit. Thank you for your time. You have a Kulja decision or Gorkha?
Gorkha, my lord, civil date in 2014 9 SSC
You have
105.
the copy of the judgment,
My lord, I have the relevant paragraph in,
paragraph.
yes, paragraph 16. This also relied in 21, my lord. I am supplying it copy.
No, okay.
It is 21, no? 21 to the. Okay,
Lordship, so far as that professor part is concerned, he is not agreed also. He is only agreed by the.
No, I am not touching,
Yes, Lordship.
I am not touching professor.
Lordship.
Professor, I am not also
He is
claiming.
not work.
I am not releasing.
Touching,
Yes,
I am also not touching.
Lordship.
Quite clear. I am only touching the blacklisting. Only because of violation of the principles of nature.
I am supplying the copy, my lord. In the other, my lord, paragraph 18, my lord.
It is right to try that the power to blacklist a contractor, whether the contract be for supply of material or equipment or for the execution of any other work whatsoever, is inherent in the party allotting the contract. So there is no need for any such power being specifically conferred by statute or reserved by contractor. Full stop. It has been observed in Pulja Industries Limited versus Western Telecom Project BSNL reported in so and so. That quote unquote blacklist simply signifies a business decision by which the party affected by the breach decides not to enter into any contractual relationship with the party committing the breach. Full stop. Before two private parties, the right to take any decision is absolute between two. Absolute and untrammeled by any constraints whatsoever. Full stop. The freedom to contract or not to contract is unqualified in the case of private parties. Full stop. But any such decision is subject to judicial review when the same is taken by the state or any of its instrumentalities. Full stop. The same implies that any such decision will be open to scrutiny, not only on the touchstone of the principles of natural justice, but also on the doctrine of proportionality. Full stop. A fair hearing to the party being blacklisted thus becomes an essential precondition for a proper exercise of the power and a valid order of blacklisting made pursuant thereto. Full stop. The order itself being reasonable, fair and proportionate to the gravity of the offense is whether the order is reasonable, fair and proportionate to the gravity of the offense can be examined by a report. Full stop. Hmm? Huh? Huh? Okay, parking. Ini ketaman perak. Does law as regards blacklisting is well settled? Full stop. Before any order of blacklisting, comma, the person sought to be blacklisted must be given the region, must be afforded a reasonable opportunity by serving him a notice, meeting the twin requirements. Full stop. And it is also clear that one cannot be blacklisted for life. And the period of blacklisting is to be proportionate with the nature of offense or nature of breach committed by the person sought to be blacklisted. To stop. When in the light of the aforementioned settled proposition of law, the learned, the respondent GMC authorities appear to have with this, sorry, at this stage, comma, it is apposite to refer to section 11. Section 11 and
46.
Mr. Nayak, section 11 and what was the
46, you relied on 46.
section?
Am I clear to you?
Section 40,
6,
46.
46,
section 11,
11,
then
46.
46. 46 and rule, some rule,
Rule 20.
20 sub rule 5.
20 sub rule 5. Another rule,
Rule 31,
30, 30.
30,
1, 4, sub rule 4.
31 sub rule 4. On examination of the aforesaid provisions contained in the Assam Public Procurement Act 2017 and Assam Public Procurement Rules, 2020, framed under the said act, it is also it has emerged that before any order of debarment, it is incumbent on the part of the procuring authority, which is GMC in the case in hand, is under an obligation to give a reasonable opportunity of being heard to the person sought to be debarred by it, full stop. It is also clear that any debarment under the act and the rules any order of retirement, any order of retirement, debarment under the act and the rules cannot extend beyond a period of 3 years, commencing from the date on which the person has been debarred. Post hoc. And again, more citation. Having regard to the facts and circumstances of the case, but reverting back to the facts of the case, it is clear that the order of blacklisting passed by the respondent GMC authorities with order dated order number so and so page 25 dated 24/7/2013 was not preceded by any kind of notice meeting the twin requirements. Does, the same, no, full stop. It does clearly, it is thus clearly established that the petitioner was not afforded the reasonable opportunity of hearing prior to passing of the order of blacklisting. Full stop. In such view of the matter, that part of the impugn order number so and so dated 24/7/2023, page 25. As regards blacklisting the petitioner from blacklisting and debarring the petitioner, blacklisting the petitioner and debarring him from participating in any kind of tender stroke auction process under the GMC from the date of issue of the said order is unsustainable in law, and the same is liable to be set aside. Full stop. It is accordingly set aside. Full stop. As the order bearing number, as the basis of the order bearing number so and so dated 4/8/2023 is the order of blacklisting bearing number so and so dated 24/7/2023, as the only basis, the order bearing number so and so dated 4/8/2023 is also not sustainable in law, and the same is accordingly set aside. Full stop. With the setting aside of the order bearing number so and so dated 4/8/2023, the order of termination passed by the respondent authorities in respect of parking place number 1 stands stands effaced, meaning thereby, the lease of parking, lease in respect of parking place number 1 is restored. Full stop. I'll come back. It has been held by the Honorable Supreme Court of India in Messrs. Eurasian Equipment versus State of West Bengal, 1975, 1 SSC 70. That an order of blacklisting does not pertain to any particular contract. To stop. The blacklisting order involves civil consequences and it casts a slur. To stop. It creates a barrier between the person blacklisted and the government in the matter of transactions. Full stop. The blacklists are instruments of coercion and it tarnishes one's reputation. Full stop. Blacklisting has the effect of preventing a person from the privilege and advantage of entering into lawful relationship with the government for purposes of gains. Full stop. The fact that a disability is created by the order of blacklisting indicates that the relevant authority is to have an objective satisfaction. Full stop. Fundamentals of fair play requires that the person concerned should be given an opportunity to represent his case before he is put on the blacklist. Right. In Raghunath Thakur versus Swenson, no notice was given to the appellant therein on the proposal of blacklisting him. First of it was contended on behalf of the state respondents that there was no requirement in the rule of giving any prior notice before blacklisting any person. First of insofar it has been held that insofar as the contention that there is no requirement specifically of giving any notice is concerned, the state respondent is found to be right. full stop. But it is held that it has been held that it is an implied principle of the rule of law that any order having civil consequence should be passed only after following the principles of natural justice. Full stop. It has to be realized that blacklisting any person in respect of business ventures has civil consequences for the future business of the person concerned in any event. Full stop. Even if the rules do not express show, it is an elementary principle of natural justice that parties affected by any order should have a right of being heard and making representations against the order. Full stop. In that view of the matter, the last portion of the order, insofar as it directs blacklisting of the appellant therein in respect of future contracts, was held to be unsustainable in law. Full stop. In that premises, that portion of the order directing the appellant be placed in the blacklist in respect of future contracts was set aside. Full stop. It was further held that so far as the cancellation of the bid of the appellant was concerned, the same should not affect. Full stop. It was further held that setting aside of the order of blacklisting in view of violation of the principle of natural justice would not prevent the state government or the appropriate authorities from taking any future steps for blacklisting the appellant if the government was so entitled to do so in accordance with law. That is, after giving the appellant due notice and an opportunity of making representations. Full stop. It was further held that it was after hearing the appellant, the state government would be at liberty to pass any order in accordance with law, indicating the reasons therefore. Full stop. In Gorkha Security Services versus Swenson. The Honorable Supreme Court of India has discussed about the contents of the show cause notice in the following manner. Para 21. Para 22. Para 27. এখানে মাজত হব, হ্যাঁ মাজত হব। UMC, right? UMC Technologies. In UMC Technologies P Limited versus Food Corporation of India,
It's also relied the Gurkha security, my lord. It's not that-
I have already said,
Yes, yes.
I have already said.
Correct.
The Honorable Supreme Court of India has observed in the following manner, paragraph 30. Paragraph 30. So your thing is taken care of, that
Lordship has quoted that.
it is open for you,
Lordship. And Lordship has interpreted only the second part of the notification. Lordship.
blacklisting.
Yes.
Blacklisting.
Blacklisting and the other one.
Yes.
So if you success in your process of blacklisting, then the other order will not survive.
Lordship.
So it is up to you.
Lordship. Oblige us.
But so far, these two orders are concerned, not sustainable because of violation of the principles of natural law. And I am not here to advise.
Otherwise, Section 5 will.
The repetition is allowed to the extent indicated above. There shall, however, be no order as to cost. But don't tomorrow, not tomorrow, Monday.
Top of the list, item number 1.
May I please your lordship? My lord, this application is against an award, my lord.
Mr. Nayak, you get these two book at a later point of time, Monday.
My lord, this is second round of litigation, my lord. The workman was dismissed from service, my lord. And in the first award, my lord, he was reinstated with full back wages. And against that, the management came before your lordship, my lord. And your lordship, by this order dated, my lord, remanded, set aside the award, remanded back the matter to the labor court, my lord, but not for retrial, but to give a decision, reasonable decision on the basis of evidence and records available, my lord.
Let us see the order of remand.
This is at page 27. No, this is page 27 is impune award, my lord. This is the impune award, but earlier award I have not annexed, my lord.
Then only you can understand what is the scope
Yes, but
of this litigation. Is it available in the
yes, it is in the record.
LCR?
Yes.
Please tell your associate to find out.
That is Justice Vipul Sharma's order.
The book of to deal.
Here, what happens, my lord?
Let me have the, okay. Because this litigation is after that order.
Yes.
লাগিলে মাতি দিম বুলি কব
কৰিব পাৰিব নেকি? এইখন দি দিয়া, দি দিয়া। পঢ়িব নোৱাৰিব নেকি? তোমাৰ এইটো কিন্তু ভাল লাগে। কোনটো এইখন আছিল? আগতে। বিপ্লৱ কুমাৰ। এইটো দি দিয়া লগতে। Eso tú, 2020. That's it. That's it.
Do you have any legible copy?
Oh, one copy is with me, my lord. It is slightly. Same condition, my lord.
এটা আমার পর প্রিন্ট আউট লব পারা না যাব না একটু অ্যাভেলেবল না হবো নাকি একটু অ্যাভেলেবল হবো নাকি হ্যাঁ
And
Right.
Anna. And another problem is there, my lord, because the evidence is in mostly in vernacular, my lord, and that copy is not legible. If your lordship permits me, my lord, I will type it out, my lord. Otherwise, your lordship, it will be difficult for your lordship, my lord, to come to a decision, my lord.
Let us see first this one. If it is legible, there is no difficulty in reading. Kajati is owned by and managed by the company registered under two of its workmen, Venudor Kisa and Embarrassingly dismissed from service pursuant to domestic inquiry relating to the charge of theft of fund bag of tea weighing about 30 kg from the factory of the tea estate. Being aggrieved by such dismissal of the workmen by his secretary raised an industrial dispute and consideration of the same in the government of Assam in labor or referred it to the labor by notification that the reference was Doyang is justified in dismissing that not that the entitled to reinstatement with full black wages neither on receipt of the aforesaid notification registered. The reference is from Australia and everything should be before the response to the state of the parties submitted in state. The proceeding before the labor court. Management examining hypothesis improve workmen in court examining in support of the case. It will be targeting to maintain at the management will not justify with a reply on it by the management. Suppose, these two are employees or workmen. There was a domestic inquiry. Thereafter, it reached the labor court on a reference. Then what is the procedure to be followed by the labor court?
My lord, labor code,
Because in a domestic inquiry, evidences, it appears evidences were laid by both the parties prior to their charges were framed. Right? Then what is the procedure?
my lord, labor code will examine whether domestic inquiry is good. It is whether it is on the basis of materials on record, whether it is supported by evidence. If it is good, my lord, matter ends there. If domestic inquiry is defective, then labor court will take evidence and examine documents and will come to a decision, my lord.
So what happened here?
Here, my lord, here,
Domestic inquiry witnesses were examined,
yes,
charges were framed.
yes,
Now thereafter, that the first labor court had held that all those things,
yes,
then that has been set aside,
yes,
that has been remanded back,
yes.
right? Now, this time, what the labor court has held? Where is the impugn order?
Impugn award is at pace. As pace to 27, my lord.
So any evidence is laid before the,
No, my lord.
not laid?
The direction of the honorable
Yes, I have seen.
single judges, I have quoted it at pace.
I have seen the main order itself. You might have seen.
Yes, my lord.
1 minute.
Right.
To decide the reference appraise on the
Yes.
basis of the evidence on record,
Yes,
keeping in mind the observations made in this judgment and order.
yes,
So available evidence,
Yes.
materials.
yes. my lord. And on
Meaning
the-
thereby the materials in the domestic inquiry.
My lord, before labor code evidence was reduced, my lord. And documents were produced, my lord, and on the basis of that, my lord, honorable single judge directed to take a decision to the labor court without taking any, my lord, further inquiry, my lord. The direction is that,
No, otherwise, what is the law? Labor court has to, I think, first examine whether domestic inquiry was proper or not.
my lord, and law is that, my lord, labor courts take simultaneously both, my lord. Labor court, domestic inquiry proceeding and evidence before labor court, my lord. Simultaneously, labor court can go into it, my lord, to take a decision. And what direction, my lord, honorable single judge? Yeah, I need to. I'm taking your lordship to that, my lord. I'm taking your lordship to the direction of honorable single judge. Yeah.
The tablet production. I did too. I did too.
My lord, I will take your lordship to the observation given by the honorable single judge, my lord, at paragraph 21. As regards the charges leveled against the workmen, it is nowhere in the evidence that they did not understand the charges. The basic charges being removal of the one tea bag from the tea estate, and the said incident being related to both the workmen, although in charge sheet framed against Mubarak Ali, the date of occurrence was not mentioned. But it was clearly mentioned in the charge made against Benudhar Tasa. Basically, both the charges against the workmen are one and same, which is removal of bag of the weighing approximately 30 kg from the factory and selling out the same for personal gain. In the reply furnished by the two workmen. And so also in the written statement, it was not contended that they did not understand the charges, same being vague and indefinite. Further, it was immaterial as to whether there was any evidence as to the place of selling out the 2T bag. The basic charge being removal of the same from the factory without authority.
This is the clear observation of the in the order of remand.
Yes, madam. And
So
thereafter-
basic charge is removal of the bag from the factory without authority.
Yes, madam. And thereafter,
So this, the other part has been discarded. It is immaterial.
yes, madam. And I will take your lordship to paragraph 23, my lord.
Yes.
For the aforesaid reason, and before that, I will take your lordship paragraph 22. In view of the above, the learned labor court could not have set aside the impugned award solely on the basis of the purported technical ground of non-mentioning of the date of occurrence in respect of Muhammad Mubarak Ali and place in which the tea bag was sold by the two workmen. Further, as noted above, there was also no proper appreciation of the evidence by the labor court. And now 23 paragraph. For the aforesaid reasons, the impugned judgment and award 19-3-2002 passed by the Labor Court Assam and Guwahati in reference case number 13 of 1999 is liable to be set aside and quashed, which I accordingly do. The matter shall now go back to the Labor Court for deciding the reference against on the basis of the evidence on record. Keeping in mind the observation made in this judgment and order, the learned Labor Court shall decide the reference afresh on the basis of the available evidence and materials as expeditiously as possible, preferably within a period within 3 months from today. This is the direction given by the Honorable Chengul Judge, my lord. On the basis of the materials available on record, directed to give a decision, my lord.
Now, whether this, the principles laid down in this Delhi Cloth and General Mills
Yes,
are applicable, still holding the field,
still applicable.
still holding the field.
Now I will take your lordship to the impugned award, my lord.
1 minute. Now, there are some principles laid down therein. Right. One of the principles is that when the management relies on the inquiry conducted by it and also simultaneously adduces evidence before the tribunal without prejudice to its plea that the inquiry proceedings are proper, it is the duty of the tribunal in the first instance to consider whether the inquiry proceedings conducted by the management are valid and proper. If the tribunal is satisfied that the inquiry proceedings have been held properly and are valid, the question of considering the evidence adduced before it on merits no longer survives. It is only when the tribunal holds that the inquiry proceedings have not been properly held that it derives jurisdiction to deal with the merits of the dispute, and in such a case, it has to consider the evidence adduced before it by the management and decide the matter on the basis of such evidence. Now, here, which one is the correct position? The labor court decided and discussed about the domestic inquiry or the evidence before it?
Evidence before it, my lord, on the basis of. the-
Evidence before
Yes,
it.
because my lord,
Let us
management
see.
examined 5 witnesses, workman examined 2 witnesses.
No, what he discussed.
Yes. I will
What he
take the-
discussed,
yes,
he
I will-
discussed the evidence before a domestic inquiry or evidence before him.
Before him, my lord. I will take your lordship to the award, my lord, at page
He
27.
should have discussed it first. Is it not?
I will take-
Domestic inquiry.
I will- I will take your lordship to
Let
the.
us see, let us see. Page-
Acquired on the following schedule, issues wise. Whether the management of Dayang Tea Estate is justified in this
Madam, when we checked up
Yeah.
the records, there is no decision that why the evidence is taken by the labor.
Evidence?
Evidence is taken by the labor court. There is nothing, just is a routine manner that the evidence was taken. So that's why this inquiry proceeding will be important for us,
Labor code evidence or domestic?
domestic as well as labor court.
You have to take certified copies.
We will apply separate purpose if there is permission of the court, because the trial court record, but we may not get it, my lord.
Okay, I got to लिख ही बोलूँगा. Both MS Photosaiji and Mr. Roy have submitted that as they do not have the copies of the evidence, the depositions of the witnesses recorded before the learned labor court, as well as in the domestic inquiry. They would they would like to have that they would like to obtain the certified copies of the same. Also, if proper application made in this regard by the parties, the office to take necessary steps in this regard.
Public.
With your lordship's permission, I'd like to make a mention for 2 items listed for hearing today. Lordship, the matters may be taken up on some other date, your lordship. I've taken the consent of the respondents as well. Item number 12 and 13.
12.
Then it would go up 2nd or 3rd week of September.
14th of September, if it is okay, your lordship.
Okay. Mr.
N. Datta.
Anand Dr. Learned counsel for petitioners. Petition.
12 and 13.
Petitioner has sought a listing of the case after 2 weeks. It is submitted that Mr.
N. Kalita.
N. Kolita, representing the respondents in the industry
Yes,
department,
lordship.
has agreed to the preamble by Mr. Dutta as sought for by the learned counsel for the parties. Is the case on 49.
Much obliged, your lordship.
Item number 2.
Mr. Mozumdar will take up your case at 3. Yes, nothing. You have deposited.
Yes.
Fact, I'm just holding the fort for my seniors to come from the IC department. I'm just holding the fort for my seniors to come and argue the matter, but the matter can start as and when the petition starts. I'm here.
Item number 4.
Your lordship, this matter may be taken up after some time or.
Let us see.
Yes, yes. May it please your lordship. Here, my lord, 2 issues. Number 1 is that whether an unregistered trade union can espouse the cause of a single workman month for it to constitute a valid industrial dispute. And second, my lord, once the registration of a trade union is cancelled, can the registrar, my lord, there being a provision for appeal, my lord, can it be vacated or reviewed without there being a specific provision there to my lord? What had happened, my lord, in an individual workman of the downtown hospital, my lord, he was transferred
to one of its undertakings in Shillong. He refused to report for duty, did not join, my lord. Thereafter, a reference was, conciliation was done. A reference was made, my lord. Now, the cause of the individual, lordship knows, my lord, an individual dispute, unless it is covered by 2 capital A of the Industrial Disputes Act, it's a case of,
I don't know anything.
my lord, 2 capital of the A of the Industrial Disputes Act, my lord, unless it's a
Let us
case
see.
of dismissal, retrenchment, or termination of service, an individual dispute does not constitute an industrial dispute.
Industrial dispute check.
Because the respondent number 5 was the workman, my lord, he, I don't think is interested because he has not appeared in spite of service.
Let us see the order first, then. Impugn order,
Impugn order is at page 67, my lord.
okay, short order, let us see.
It's a short order.
Management certified.
Both parties are present. The workman side filed a written objection against the maintainability of this case. Their play is that the case is maintainable. As per the management, the workman union represent the case of Tilak, reference by reference case number so and so. As per the management, the additional commissioner come public information officer informed them. The management that it is, I know the English is anyway, that it is informed by a letter dated so and so in reply to the aforesaid letter dated so and so. It is stated that at the time of it should be inception. Inception of the union in question, the trade union had 42 members. However, the additional labor commissioner comes so and so does not know about the members of their unions on 1/5/2013, as the said union had ceased to exist with effect from 1997. Therefore, as per the management, this case is not maintainable. Hence, be set aside with reference. In this regard, the management side filed a decision of Honorable Supreme Court. The decision in so and so was a so and so reported in so and so. In that case, it is submitted by the learned representative of the management that it is also reproduced the relevant portion as follows. Chapter 3 of the Trade Union Act 1926 sets out rights and liabilities of the registered trade union. Under the said enactment, an unregistered trade union or a trade union whose registration has been cancelled has no manner of right whatsoever. Even the rights available under the ID Act have been limited only to those trade unions which are registered under the Trade Unions Act 1926 by insertion of clause 2QQ in the ID Act with effect from 21/8/1984, defining a trade union to mean a trade union registered under the Trade Unions Act 1926. This is the quotation mark. It is submitted on the basis of this observation of the Honorable Supreme Court. This case is not maintainable as the workmen who represent Tilak Datta, their trade union still not in existence. Therefore, it is paid to dismiss the reference case. However, the other side submitted that there is no reason to challenge the maintainability of a case, especially the reference case. The union may be there or may not be there, but it does not mean that there is cessation of cause of action. Even it is submitted that unregistered trade union also can represent the grievance of the union member. In para 4, it is elaborately written that the management cannot raise the question of maintainability at the initial stage. Moreover, as per law, an unregistered union can also raise industrial dispute. Even a group of workmen can raise dispute. So it is submitted that for argument's sake, if it is assumed that the union has no registration at present, even then the union can raise industrial dispute. It is also submitted that ruling cited by the management does not have any relevance. It is also submitted that sum and substance of the ruling is that the unregistered trade union does not have the same right whatsoever, right available to a registered trade union, and also given under ID Act. It is also submitted that it is a fact that they have not same right and privileges like registered trade union. Even then, the decision of the Honorable Supreme Court does not bar representation of the workmen by an unregistered trade union. Considering the submissions and also the citation, I feel the learned advocate for the workmen has rightly submitted that therefrom the citation I do not find barring or preventing an unregistered trade union to represent the member of. As a result of that, I have found that the plea raised by the management side is on maintainability. I cannot accept. So the reasoning is that he feels, my lord. Absolutely no reasoning.
What is your objection or petition? This is the objection petition 65.
My lord,
What is 65?
65 is their objection to my objection regarding the petition filed by me raising the issue of maintainability. My issue, 60 is my application,
60.
page 60, madam. To decide the maintainability of the reference as the preliminary issue.
But this parties are Walkman Sri Tilak Datta.
Yes, represented by the union.
Who is the reference then?
The reference is at page 55, not 55. The notice issued by the, is at page 23, madam. First party is one of the secretary, general secretary, Downtown Hospital Employees Union.
Hmm.
And parties, this is manager Downtown Hospital.
Which statutory provision requires compliance for which debars unregistered trade union?
Well, we have to go from the definition, madam. Lordship takes up the Industrial Disputes Act.
Industrial.
Two K, madam. Lordship gets it. Industrial dispute means any dispute or difference between employers and employers, or between employers and, Lordship will kindly note, workmen, or between workmen and workmen. It is not workman, my lord. It is in plural, which is connected with the employment or non-employment or the terms of employment or with the conditions of labor of any person. Now we come to 2 capital A, my lord.
Two capital.
2 capital A. This was inserted with effect from 1965 and then amended in 2010.
Hmm.
2 capital. Where any employer discharges, dismisses, retrenches, or otherwise terminates the services of an individual workman. Here it is workman, my lord. Any dispute or difference between that workman and his employer connected with or arising out of such discharge, dismissal, retrenchment, or termination shall be deemed to be an industrial dispute, notwithstanding that no other workman nor any union of workmen is a party to the dispute. So only in a case of dismissal, discharge, or retrenchment or termination of a workman, the espousal by the union is not necessary. So transfer being an individual dispute, it cannot be an industrial dispute unless it is espoused by the union or a substantial number of workmen. Subsection 2 may not be relevant. This is regarding conciliation and all, because here it's not a case of retrenchment or dismissal. The lordship will also take the definition of trade union at 2QQ. Trade union means a trade union registered under the Trade Unions Act 1926.
What was the action taken against this workman?
He was transferred, madam. He did not
From-
join.
Were from the original application? Anything? Which the unregistered trade union,
I'm coming to that. Because now we are not on the merits of the case.
right, but action. What action was taken by the management against the employee?
No action, ma'am.
No, that is transfer. You are
Yes.
saying transfer.
Yes, transfer.
Where it is reflected?
Achha.
Transfer to Shillong.
He was
Where it is
transferred to Shillong.
reflected? Maybe they are espousing, unregistered trade union may be espousing it.
I'm coming to that.
Huh.
Because the transfer order specifically is not, is at page 22, my lord.
22 is there.
22.
So this is the genesis.
This is the gen.
And in what manner they have represented this unregistered, this downtown hospital employees union?
Yes, my lord.
You want to say it is an unregistered?
It is an unregistered. Not unregistered, its registration was cancelled. When initially it was
This
registered,
was of 2009, right?
This is a-
le-
so
transfer order
2009.
is 2009.
2009, lordship turns to the next page, 23.
Mhm.
This is the reference, start of the reference, 2011. He never joined. Now he is working somewhere else. He is not interested because he has
So-
not come.
You want to say that this 23 notice, this register or industrial tribunal,
My lord,
uh, could not have taken cognizance of the petition, whatever application filed by this body having no registration.
no, I'm not on that. my lord. Procedure is that once there is a dispute apprehended, it is referred for conciliation before the conciliation officer. When the conciliation fails, the conciliation officer sends it to the government. That conciliation has failed.
No.
Government makes the reference.
This industrial tribunal, unless there are two things, unless it is in dispute of an individual workman falling in the category of dismissal termination, it could not have taken cognizance of so moto on its own.
It otherwise also cannot.
No, that is what I am asking.
It cannot, otherwise also it cannot take suo moto cognizance.
That is what I am saying.
It cannot.
2A.
2A, when it is a case of dismissal, the workman can directly approach the tribunal.
That is what I am
That is what.
saying.
Here that is not, he has not
No,
approached
that
directly.
is what I am saying,
Yes,
Mr.
madam.
Deka,
Yes,
that unless it is in a category of termination, and workman cannot directly approach
Yes,
the
absolutely,
industrial tribunal.
absolutely, absolutely.
Secondly, a body having no registration cannot espouse the cause of an individual workman. That is your submission.
Absolutely.
Have I understood
Yes,
correctly?
absolutely, absolutely.
So what they filed before the tribunal?
No, tribunal initially pleadings were over, my lord. We filed our written statements, everything, because we did not know about the registration of the union.
What was filed by that body having no registration before the tribunal?
No, my lord, they
The
did not,
document they have filed.
they did not file anything. My lord. Here the procedure is that conciliation will be held before the conciliation officer. Conciliation will, when the conciliation fails, the matter is referred to the government. Government forms the issues and refers it to the tribunal. Thereafter, the tribunal issues notice. So this notice at page 23, my lord, this is after the reference under section 10. If your lordship kindly comes to page 23, my lord. Reading it will be clear. Whereas the dispute noted above referred under the provisions of section 10(1)(d) of the Industrial Disputes Act by notification number so and so to this tribunal for adjudication in respect of the matter specified in the schedule. The schedule is on the next page, madam. Page 24. So the government of Assam has referred these two issues for adjudication before the tribunal. Accordingly, tribunal has issued this notice.
Come to 2K.
Yes, ma'am.
Then why three last words are appearing in 2K?
Which word, madam?
2K, last three words.
Of any person?
Yes.
Yes,
Why this any person
of any person. So
is
in
appearing?
industrial dispute can be in respect of any other person also. But if
Which
it is a
includes a workman.
inclusive word,
So if the body having no registration, that cover is gone, but still under it, the person remains.
no, it is settled law, madam.
What's settled?
It is settled law. There are many judgments, madam, to that effect.
Show me one.
Yes, yes.
Regarding body lordship, page 59 lordship.
Hmm?
Regarding union lordship, page 59 lordship.
59.
59 lordship.
59 is what?
It says that for some period of time they
I
are
have not even gone to that aspect, madam.
it was restored in 2009 lordship.
That is my second line limb, madam. It could not have been restored. I got AIR 1963 Supreme Court 318, madam. Paragraph 7 of the judgment. May I read? The terms of reference by the government of Bombay under section 12(2) indicate that the dispute was primarily between the Hindu Bombay and the appellant, a single employee, relating to his individual claim in which the other employees of the Hindu were not directly interested. In Central Provinces versus so-and-so, this court, after setting out the three possible views on the question whether a dispute by individual workmen may be regarded as an industrial dispute within the meaning of section 2K of the Industrial Disputes Act 1947, observed the preponderance of judicial opinion is clearly in favor of the last of the three views stated above. That is, a dispute between an employer and a single employee cannot per se be an industrial dispute, but it may become one if it is taken up by the union or a number of workmen and there is considerable reason behind it. Notwithstanding that the language of 2K is wide enough to cover a dispute between an employer and a single employee, the scheme of the Industrial Disputes Act does not appear to contemplate that the machinery provided therein should be set in motion to settle only disputes which involve the rights of workmen as a class, and that a dispute touching the individual rights of a workman was not intended to be the subject of the adjudication under the Act, when the same had not been taken up by the union or a number of workmen. The view was reiterated in so-and-so. Therefore, the applicability of the Industrial Disputes Act to an individual dispute as distinguished from a dispute involving a group of workmen is excluded, unless the workmen by a body or a considerable section of them make common cause with the individual workman. The dispute in the present case being prima facie an individual dispute, in order that it may become an industrial dispute, it had to be established that it had been taken up by the union of employees of the Hindu Bombay or by an appreciable number of employees of the Hindu Bombay. Counsel for the appellant contended that the dispute was supported by the Bombay Union of Journalists, of which so-and-so was a member, and that in any event, it was supported by so-and-so and so-and-so, who were the only other employees in the establishment. He also contended that in any event, the dispute having been taken up by the Indian Federation of Working Journalists after it was referred to the tribunal, it had become an industrial dispute. By its constitution, the Bombay Union of Journalists is a union not of employees of one employer, but of all employees in the industry of journalism in Bombay. Support of the cause by the union will not, in our judgment, convert the individual dispute of one of its members into an individual dispute. The dispute between the Hindu Bombay and so-and-so was in respect of alleged wrongful termination of employee. In that time, the 2 year had not come in. It would acquire the character of an industrial dispute only if it was proved that it was before it was referred, supported by the union of the employees of the Hindu Bombay of any appreciable number of cases. In Workmen versus Dimakuchi Tea Estate versus management of Dimakuchi, this court held by a majority that the two terms of an industrial dispute as defined by section 2K, subsection K of 2 of the Industrial Disputes Act must therefore be, number one, the dispute must be a real dispute capable of being settled by relief given by one party to the other, and number two, the person in respect of whom the dispute is raised must be one in whose employment, non-employment, terms of employment, or conditions of labor, as the case may be, the parties to the dispute have a direct or substantial interest, and this must depend on the facts and circumstances of each case. In that case, certain employees sought to raise a dispute about a person who was not a workman. In the present case, members of the union who were not workmen of the employer against whom the dispute was sought to be raised seek by supporting the dispute to convert this prima facie an individual dispute and an industrial dispute. The principle that the persons who seek to support the cause of the workmen must themselves be directly and substantially interested in the dispute, in our view, applies to this class of cases also. Persons who are not employees of the same employer cannot be regarded to be so interested that by their support they may convert an individual dispute into an industrial dispute. The mere support to this cause by the Bombay Union so-and-so cannot therefore assist the claim of so-and-so to convert it into an industrial dispute. And the Dimakuchi judgment is from our High Court, Malon. And paragraph 15, Malon.
Dimakuchi is not directly 1 and 2. Two conditions are there anyway.
15 last few lines, Malon.
Yes.
let us read 15. The tribunal observed that even if the reference of so-and-so and Tiwari ceased to support the cause of so-and-so, being the only person who could support the cause, the reference must fail. And in support of that view, relied upon the judgment of a single judge of the Madras High Court in so-and-so. But this decision has since been overruled by a division bench of the Madras High Court in the so-and-so case. In that case, the court observed it must be held that the jurisdiction of the labor court to proceed with the matter wholly depends on whether the industrial dispute referred to it for adjudication existed or was apprehended on the date of the reference and not on a subsequent date. Having regard to the relevant statutory provisions, it must be held that the jurisdiction of the labor court to proceed with and adjudicate upon an industrial dispute stems from and is sustained until it makes an award and the same becomes enforceable by the reference itself, which has been made on the basis of an industrial dispute existing or apprehended on the date of the reference, and that the jurisdiction of the labor court to proceed in the matter is not in any way affected by the fact that subsequent to the date of the reference, the workers or a substantial section of them who had originally sponsored the cause had later realized and withdrawn from it. In our view, these observations correctly set out the effect of a subsequent withdrawal of support by the workmen of a cause previously espoused by them. In each case, in ascertaining whether an individual dispute had acquired the character of an industrial dispute, the test is whether on the date of the reference, the dispute was taken up as supported by the union of the workmen of the employer against whom the dispute is raised by an individual workman or by an appreciable number of workmen. If so-and-so and so-and-so had prior to the date of the reference supported the cause, by their subsequent affidavits, the reference could not have been invalidated. But as we have already observed, there is in fact no support to the cause. So this is on the facts. What I am on is the middle portion, my lord, is the date of reference is relevant. Whether on the date of reference, there was valid support by the union or by a substantial number of workmen. So this is my first limb of argument, my lord, that it is an individual dispute, not an industrial dispute. And regarding the support of the substantial number of workmen, my lord, I'll refer to, my lord, 1975, 4 SCC page 838, my lord. Para 8. It is no doubt true that on a superficial reading of the above decision, it
I
can
haven't gone into that.
my lord.
So this man was a general secretary.
my lord. Appears to be, my lord. Because it is the functioning of the union.
Then what is the statutory provision regarding transfer of a general secretary of a union?
No, he has to be a protected employee.
Right.
Only then he is not a protected employee.
That is
And
what
the union is not valid. Union is not valid. Minimum, there is a minimum requirement of 7 members.
7.
7. 7 is the minimum requirement for having a valid trade union. Man. Take your lordship to the Trade Union Act. Man.
Trade union act.
Trade Union Act, Section 4 is the mode of registration.
When the registration revived,
No, before that, my lordship will kindly come to page 9A. I mean, section 9A.
otherwise, if he is an office bearer of a valid trade union, what is the protection under the law?
A protected employee, my lord, certain actions cannot be taken, my lord.
Transfer is one of them.
But he is not the general secretary. The reference is in the name of the general secretary. He is not the general secretary.
No, we'll see that, but I am asking about the provisions.
That I have to see, my lord.
Because at least that I know that office bearer of a union,
Yes, madam. There are certain protections are there.
that one of them is transfer.
I'm not.
Yes,
It could.
because I have read in one judgment of Justice Amitabh Roy. That is why
Yes.
I remember reading that, but I don't know. But
that-
office bearers, office
can.
bearers of a trade union. Trade union means really in all aspects.
There is a. term
He is basically some protection
Yes.
is there.
Yes.
And one of them is say transfer from the head office. Say.
Could be, my
Right.
lord, and there is also some
Right.
protection against.
Something is there.
It is there, it
Some
is there.
protection is
Yes,
there.
that I have to look
Now,
into that.
this body is representing that he was their general secretary.
He was.
No, I am saying about 2009.
Yes.
Right, elected Tilak Datta as the general secretary of the union.
When?
The union duly communicated this fact to the management and requested to treat the so-and-so as office bearer, including so-and-so as protected workman according to the provisions of industrial workman.
Lordship is reading
Page 34, paragraph 8.
34.
Now that this definition must be in the Industrial Workman Act. They are referring to.
Now, this they are referring to the earlier round of litigation, madam. In 2007, There was an earlier round of litigation, my lord, that ultimately settled by this honorable court,
No,
where we had dismissed them, my lord.
I have read.
My lord,
Paragraph 7 you read, then you read paragraph 8. Management by its order 1/2/2007 asked the workman Tilak Datta to join his duty at an early date. And in terms of the said order, Tilak Datta joined his duty on 5/2/2007.
yes,
That is done. 2007, that story is over.
gone.
Then, paragraph 8, after reinstatement of the workmen, the workers elected a new executive committee of the union and elected Sri Tilak Datta as the general secretary of the union. The union duly communicated this fact to so-and-so and to treat him as protected workman. Then the story starts, 14/3/2009. And if that, when the body represented the cause of Tilak Datta, if with a, on that date, it is a valid body, it could be a industrial dispute,
Yes, yes.
right?
On the date when the
We'll see to that.
espousal is there, if
We'll
it is
see
a
to
valid
that, but
body,
let us
yes,
be clear on the facts.
yes, and on the point of law, and that is the position, ma'am.
Let us clear on the facts.
Yes,
It is not that only Tilak Datta has been identified. Whether he has been identified as a general secretary of the union of a valid trade union,
exactly, ma'am.
right?
Right.
So what is the protection otherwise? Let me know the law because I am not quite aware of the law.
This regarding protected employee,
Yes.
my lord, that portion I'll have to see, my lord. It is there,
Because this much I know that some protection is there.
yes,
for
yes, the
office
protection is
business.
there, my lord.
Yes, Mr. Gogoi, can you highlight this?
Section 30.
Unless
Section
you
30, Lordship.
provide the assistance, it will be difficult on labor law.
And
So many provisions, so many. One is there, 2ZG. 2ZG is executive.
Section 33(4).
We'll see to that.
In every establishment, the number of workmen to be recognized as a protected workman for the purpose of subsection 3 shall be 1%.
Section,
33(4), Lordship.
let us see. 33.
4, Lordship.
4.
34, Lordship.
Too many 33 A, B, C,
Lordship, page 86.
95 here.
95, if lordship is having the same book, it is 95. in my-
95. I have the whole.
No, the number of to be recognized as provision for the purpose of subsection
Section
3
3, Lordship.
shall be 1% of total number of workmen employed therein, subject a minimum of 5 protected and a maximum of 100 protected. The appropriate government make rules providing for a distribution of such protection among various state unions, if any.
So, Lordship, we
Let us
have to
see what is
we
subsection
have
3
to
then.
conjointly read,
No
Lordship,
employer
3 and
during the pendency of any such.
3 and 2 also, Lordship.
Huh?
2 also we have to read, Lordship.
Let us read 3.
Lordship.
What is the mode of declaring a workman as protected?
Lordship,
workman?
explanation part is there, Lordship.
Huh?
3 explanation part, Lordship.
33 explanation.
3 there is
Okay.
explanation part, Lordship. A protected workman in relation to a style means a workman who, being a member of the executive or other office bearer,
is recognized as such in accordance with the rules made in this behalf, then we have to see the rules again.
Prior thereto, my lordship will read the main section. This is only during the pendency of a proceeding, not otherwise.
That is why I am
That is what-
asking, that is why I am
That is why.
asking that whether they are saying that please treat him as protected workman. That
Yes.
is what they are contending. Then suppose it will be a situation you do not recognize him, protected workman. Whether that denial will be a deemed recognition or not.
If I may, my lord. That is one aspect. The other aspect.
You may not acknowledge him as a, by your, say, either arbitrary action or non-arbitrary action.
No, my recognition or not recognition, that is one aspect. Protection is only during the proceeding, my lord. Transferring him per se, there is no bar. Suppose a proceeding is pending before the labor court.
Question is, on 14/3/2009, you have transferred.
Yes,
Right. Now, what is their case? Whether they have, because he joined in 2007.
yes.
We want to know. because
2007?
It is silent paragraph 8, when they sought,
No, my lord,
when the new
My lord.
election body was sought.
just for a moment, my lord. On 14/3, I have transferred him. If he is entitled to, let us assume that he is entitled to protection. Let us assume for a moment. So to be entitled to protection under 33 of the Industrial Disputes Act, on 14/3/2009, there must be a proceeding pending. Only then he is protected, my lord. Lordship will kindly come to 33. 33 heading is conditions of service to remain unchanged under certain circumstances during pendency of proceedings.
Which part you got?
33, page 95, the heading.
33.
It is not that once you become a member of your union, you are entitled to protection. Protection is only when there is a proceeding pending. So on 14/3/2009, was there a proceeding pending? If no, my lord, then this is redundant. That is on the assumption that it is a valid union. If it is not a valid union, then the entire question goes. Thirty-three starts during the pendency of any conciliation proceeding before a conciliation officer or a board or any proceeding before an arbitrator, a labor court or tribunal or national tribunal in respect of an industrial dispute. No employer shall, in regard to any matter connected with the dispute, alter to the prejudice of the workmen concerned in such dispute the conditions of service applicable to them immediately before the commencement of such proceeding, or for any misconduct connected with the dispute, discharge or punished, whether by dismissal or otherwise, any workman concerned in the dispute. So this protection is only during pendency of a proceeding, not
I am
otherwise.
not still satisfied, because once he is protected, there is something
No,
attached to it.
Protection to
This
what extent?
33 years, 33, I could understand.
Protection to
But
what extent?
I am still not convinced that once he is an office bearer of a registered trade union, there is no say protection attached to it.
That aspect we'll have to have.
Because this
But if
33
we
is
go by
regarding
33
pendency of the proceeding.
33 is pendency and 33 only speaks of protected workmen.
And if this on 14/3/2019, prior to that, he is an elected office bearer of a validly registered trade union, then it should be different. Now, when it was restored,
Restoration part, we'll have to go, my lord. One by one, my lord.
2009 lordship. Page 59 lordship.
Lordship will come to 55 page.
During what period it was? There was no registration of the trade union.
Lordship will kindly come to 56 again, my lord. 55, they say from 1997, it is not there.
Mhm,
On page 56, there is a clarification.
mhm.
In continuation of this office letter under reference, I would like to inform you that though so and so, but subsequently it has come to notice, third line from the bottom or top. my lord. Subsequently, it has come to notice that the union has submitted a prayer petition in the year 2009 for withdrawal of their cancellation order, and accordingly cancellation order was vacated in 2009. By this office letter under memo number so and so dated 3/6/2009. However, it appears that from the file records that despite restoration of cancellation of registration in 2009, the union fails to comply with the statutory norms and no information available after 2009. Then page 57. 58 is the original, 57 is the typed copy. Whereas under noted registered trade unions have willfully neglected and in spite of notice issued by me contravened section 28 of the Trade Unions Act so and so by not submitting the annual return for the year 1998, 2 months previous notice as provided under the proviso under subsection 10B of the Trade Union Act has also been served by this defaulting trade union so and so. Now, therefore, in exercise of the powers conferred by 10B of the Trade Unions Act, I say so and so do hereby withdraw, cancel the registration certificate of the said registration with effect from 21/2000. Now, the next order 59, it says that it is vacated.
So that is 3rd June 2009.
3rd June 2009. No, I am on that aspect also, whether that can be done. I'll come to that.
Which one? You
Whether
are challenging this order, 59.
I'm not challenging, I'm saying that this is void of an issue.
That cannot be without challenge. A statutory authority has exercised their power, passed an order.
Lordship will
Without
consider,
challenge,
Lordship will consider, I'll rely on 2 Bombay High Court judgments, my lord.
what is the challenge here?
Now, challenge is that the reference is bad. Challenge is that to that order, my lord.
Only 28/2013 order.
Yes.
We will not embark upon that
So, no, my lord.
journey.
For that,
That
Lordship
whether
will-
this 59 order is bad or wrong.
that Lordship will have to consider whether the trade union is valid or not.
But
For that, Lordship will have to, because the date is 36/2009.
3/6.
3/6. So the date of reference, Lordship will have to see. What is the date of reference?
5/8.
No, my lord. Not 5/8. 5/8/2011 is the date of reference. What is the date of dispute, my lord? 14/3. Espousal will have to be that, my lord. Cause of action arose in 2009.
Right, by that time, this has reached the tribunal. If the body espousing the cause of the workman is valid, then
Lordship will kindly come to page 35.
yes.
Para 13. Union raised an industrial dispute before the Assistant Labour Commissioner Guwahati on 30/3/2009 on the issue of malafide transfer of Tilauto. So raising of the industrial dispute is on 30/3/2009.
Whose document is
This is their WS.
Yes. Consolation was initiated.
Yes,
There was parley.
that is the beginning of the dispute, my lord.
Right.
Constitution is 11.
Which is of 11?
Section 11. Section 11 of the Industrial Disputes Act.
Yes, which part you want to show? Which part you want to show?
Subsection 1, subject to any rules that may be made in this behalf, an arbitrator, a board, court, labor court, or tribunal or national tribunal shall follow such procedures so and so. 2, a conciliation officer or a member of the board or court or the presiding officer of a labor court may, for the purpose of inquiry into any existing or apprehended industrial dispute, after giving reasonable notice, enter the premises so and so, so and so. So it is this 11 is the duty of the officers, my lord, and 12, my lord. 12 is the duty of the conciliation officers. Subsection 1. Where any industrial dispute exists or is apprehended, the conciliation officer may, or where the dispute relates to a public utility service and a notice under section 22 has been given, shall hold conciliation proceedings in the prescribed manner. So the moment you are holding conciliation proceedings, the industrial disputes have started.
So it could be a situation that on 30/3/2019, this body may not be having valid registration. Conciliation happened, failed, whatever. Then matter was referred under section 10 perhaps.
Yeah.
Government. And it reached and it came out of the government on
2011.
5/8/2011. And thereafter, in September 2011, this industrial tribunal issued a notice.
Right.
And by that time, the body representing the workman became valid. It ceased to be unvalid. So whether it was at that time, it was not valid, but by the time it reached the government, it became valid. It is not that what this court originally thought, that simple thing 2A will come. It is not a case of 2A because he appears to be an office bearer, general secretary of the union.
The general
That
secretary,
is what they are espousing.
so general secretary is not entitled to a blanket protection.
Have you addressed that part?
That part is,
Somewhere. Paragraph 8 you have addressed.
that is paragraph. 8
Because
is a written
it is
statement.
clear that he is the general secretary, elected secretary of the union, and matter was informed to you.
Maybe. Maybe, my lord.
Maybe means.
Maybe he's,
makes a lot
no,
of
I'm
difference.
coming to that.
Ah.
But he has
Have
to
you
be,
address anything?
no, am I required to, my lord, the first foremost, because he has
Okay. it
because,
is
uh,
said that
33 of.
I
33 of-
record that.
Lordship will
You are
record
not
that.
required. When a
33
court asks,
33.
when a
33
court asks
is
you
clear,
yes
my lord.
or no, you are addressing that you are not required to answer it.
My lord, I have answered, my lord, at page 42.
That is what I asked. Have you addressed that issue or not? Your answer is you are not required to answer.
I'm not required to otherwise, because 33 is
When
clear, my
the
lord.
court asks yes or no, what is this? I have simply asked you whether you addressed
My lord,
the issue or not.
the issue.
Your answer
issue-
is I am not required to answer.
No, I'm not, I'm required not.
It
required
is
to,
a query
because-
from the court only.
Because, my lord, 33 is clear, even
Your
if,
second submission could be that.
even if it is his workman, the union, he is not entitled to
That should
protection.
be preceded by either
Right.
yes or no. Thereafter, you should say that yes, I was not required to answer it. Where is 43?
42, para 6.
Paragraph 6.
Because I have at the beginning said I am not very conversant with. I am clear. I am very clear about that aspect that I am not very conversant. When you said about 2A, well, I have not seen it. I have seen it for the first time. Right. I have said I am not clear about that. My very first statement before you.
So, my lord, let us go one by one.
Yes, 42.
42, para 6.
Okay. Okay.
So my first submission is this one.
Okay.
Industrial disputes on their own admission starts on 33, 2009. On 33, 2009, I have shown that it is not a valid trade union. For it to be an individual dispute, to be an industrial dispute, espousal is necessary. Either from the union or from a substantial number of workmen. And in that judgment, 63 judgment in itself, it says, my lord, the espousal must be on the date of dispute. Even if it is subsequently withdrawn or subsequently, there it was a case of withdrawal, even if it is subsequently withdrawn, it does not matter. Now, I think Lordship will kindly come to the Trade Unions Act, my lord.
Just that decision you have cited, that is of, just I'll, 1962, just that paragraph 7. I'll just have a look. Become one. If it is taken up by unions. Notwithstanding that the language uses white now to cover a dispute between employers, the scheme of the industry does not appear to contempt that the machinery provided therein should be set in motion. Mr. Dekka, just paragraph 7 of the judgment,
Yes,
that quote unquote portion,
yes.
just let us read slowly.
The preponderance of judicial opinion is clearly in favor of the last of the three views stated above. That is, a dispute between an employer and a single employee cannot per se be an industrial dispute but it may become one if it is taken up by the union or a number of workmen, and there is considerable reason behind it. Now, one thing, Lordship, I'll make it clear, madam. At that point in time, 2 capital A had not come in. So in my humble understanding, my lord, the law relating to industrial dispute is like this, my lord. If it is an industrial dispute, suppose I transfer someone, suppose I inflict a punishment of stoppage of increment, he cannot come directly to the industrial court. His cause has to be espoused either by the union or a sufficiently large number of workmen. Then the matter will go to the government, my lord. Either conciliation under 12 and then reference under 10. But if it is a case of dismissal, my lord, he directly approaches the labor court. In the first case, where it is a reference from the government, the issues are framed by the government. But if it is a case under 2A, my lord, 2 capital A, then the issues are framed by the labor court.
Now let us read further, notwithstanding.
Yes, notwithstanding that the language of 2K is wide enough to cover a dispute between an employer and a single employee, the scheme of the Industrial Disputes Act does appear to contemplate that the machinery provided therein should be set in motion to settle only disputes which involve the rights of workmen as a class, and that a dispute touching the individual rights of a workman was not intended to be the subject of an adjudication under the Act, when the same had not been taken up by the union or a number of workmen.
Does appear to contemplate and machinery provided therein should be set in motion to settle only disputes which involve the rights of workmen as a class. And
Lordship reads even after that quoted portion. This view was reiterated in so-and-so versus so-and-so. Therefore, the applicability of the Industrial Disputes Act to an individual dispute as distinguished from a dispute involving a group of workmen is excluded, unless the workmen as a body of should have been of a considerable section of them, no, or a considerable, as a body or a not of or a considerable section of them make common cause with the individual workmen.
so here is a case, this body has taken up the case of individual work.
Yes,
The question is validity of
yes.
whether registration or non-registration ultimately.
Now,
They
even if
can take up the call.
yes, now I go a step further. Suppose the body is not recognized. The word uses considerable number. So this considerable number, my lord, will have to read vis-a-vis the total numbers in employment. I've got a judgment to support my argument, my lord.
No, we are only considering this body.
So if your lordship is considering only the body, then we'll have to move to the Trade Unions Act.
Because your objection is to that only. And
No,
the
my lord, my objection is to that, but if your lordship comes to the finding that even if it is not a valid body, but it is
We'll try.
supported by a sufficient number of workmen, then also I may not have a case.
Okay,
Although I'm making this argument in support of the workmen. But even if it is invalid, suppose there is no union, suppose an organization does not have a union, so will it be a case that an individual workman cannot address his grievances? It can, my lord, if a substantial number of workmen support its cause.
no, because this has to be, since they are representing rightly or wrongly, that he was our general secretary, elected general secretary.
Yes.
Right? That is what they are saying. And this office bearer, say president or secretary, has some privilege in industrial dispute. But I have read, that is why I am saying,
That I
regarding transfer,
I'll look
right?
into.
And in a judgment delivered by Honorable Justice Amitav Roy. but I could not lay my hands as on date. But that an office bearer of a registered employees union is not to be transferred outrightly. There is some protection attached. That is why I am, because otherwise things may go wrong for me.
No, that aspect I'll also have to look at,
Right.
because
So
far as-
Chaudhary, can you
But-
highlight this? Because I am saying time and again, I am not very.
Even
comfortable.
I am not very well versed with this subject, but
Because-
I do remember coming across a case, my
Yes.
lord, where the precept was, my lord, as general secretary or office bearer or president is not to be transferred in the normal. I think there is a judgment.
Something is there, I have
During
seen.
pendency of a proceeding.
No, that is,
Proceeding is pending.
I'm not very sure what.
I am
the
also not
background,
sure,
what is
right?
the Circumstance.
I am also not sure.
Ah.
That is why I am asking you
No, no,
repeatedly.
let me
But
have
there
a,
is something
Yes.
that even if otherwise he is working in the office as a general secretary, there is no cause of concern for anybody. But suddenly if he is transferred, there is some protection. That is
No, my lord,
what I am.
Even I do remember, my lord, there is a case where, my lord, I think. there is
Unless
an
I am
order.
not sure, I cannot,
Hmm.
obviously.
Hmm.
So that is why, Mr. Deka, I am slight,
I'll look into it.
so that
Yes, my lord.
something should not happen due to my ignorance.
That should be,
Ignorance of the law will be par incuriam. Is it not?
Yes.
So that is why somewhere I have read. And at least I remember that one judgment delivered by Justice Amitava Roy. Honorable
into it.
Justice Amitava Roy.
Yes.
It is there. So that is why I am slight
should we,
without being sure.
should we proceed further, my lord, then?
Just to facts. Okay, but
Because now the factual part is over. Now
what
I'll have to
trade
take the-
union,
the
trade union act, what you want to refer?
No, my lord, if that aspect has to be looked into,
No, that's
then
no issue.
Trade Union Act Lordship comes to section 4. It is how it is registered. Now, I take your lordships to 9A. 9 capital A. A registered trade union of workmen shall at all times continue to have not less than 10% or 100 of the workmen, whichever is less, subject to a minimum of 7.
Anything about office bearer here?
No.
It is
I
silent.
have- No, I will not say no directly, my lord, but I have not found it.
Yes, Mr. Gugu, anything other than 33? Other than 33 protection, any idea? Dates are clear.
Lordship.
Mr. Dekan, dates are clear.
Dates are
that
clear, only-
33, 2009, it
Only,
started.
only, my lord, section 15, I'll just draw your lordship's attention to. The rights and liabilities of registered trade union. Why I am taking your lordship, because I'll be relying on a judgment which refers to chapter 3, my lord.
Section 15.
15, chapter 3 is the heading.
Mhm.
Objects
ID
on-
Act. Industrial dispute.
No, trade union act.
15. Mhm.
So
Rights
these
and
are the objects on which general funds may be spent. These are the rights and liabilities of registered trade union, my lord. C and D may be seen, my lord. Prosecution or defense of any legal proceeding to which the trade union or any member thereof is a party when such prosecution so and so, so and so, so and so. And then the conduct of trade disputes on behalf of the trade union or any member thereof. Why I have taken your lordships to this manner? Because judgment of the apex court says that an unregistered trade union cannot be entitled to this.
Yes.
And two Bombay High Court judgments, I'll be relying on that aspect, whether registration can be cancelled or restored. Although Lordship has expressed that since that is not under challenge, even then, my lord, I'll place those judgments, my lord. Because because there is a power of review, I mean appeal, my lord, if your lordship kindly comes to section 10 of the Trade Union Act.
Rightly or wrongly, the order has been passed by a statutory authority,
Lordship, I'll just
59.
show section 10 and 11. Because even if it is 33(6), my lord, I am protected because it is 33. Even then, my lord. Section 10 of the Trade Union Act. A certificate of registration of a trade union may be withdrawn or cancelled by the registrar. Number B, this is the power exercise. If the registrar is satisfied that the certificate has been obtained by fraud or mistake, or that the trade union has ceased to exist or has willfully and after notice from the registrar contravened any provisions of this act, or allowed any rule to continue so and so and so. And 11 is the appeal provision. A person aggrieved by any refusal of the registrar to register a trade union or by the withdrawal of cancellation of a certificate or may, within such period as may be prescribed, appeal. Number A, where the head office of the trade union is situated within the limits of a presidency town, to the High Court, or
No, why you are showing this?
because when it is cancelled, my lord, the remedy is appeal before the Labour Court. So when the registration was cancelled by the registrar, my lord, the remedy before the union is to file an appeal before the Labour Court under 11.
You want to say that the registrar does not have any power to revoke?
No, it cannot. These things required to be done, my lord, has to be done. It is a power. It is a power exercise of power, and without the power being there in the act, there is no power of review. That is what the Bombay High Court says, my lord. The division bench and the single bench, my lord. That once you have passed the order, you are functus officio. Even in the Labour Court, my lord, once the award is passed, for 30 days, the clerical errors may be corrected. Once it is published, my lord, no power of review. It is functus officio.
Okay. So he has no power to revoke his own order. That is what you.
That is what I am trying to support. It is the Labour Court where they have to come, the union, I mean the union, my lord. So, my lord, facts are, dates are not in dispute. I've shown the law,
Just one or two provisions of law
just
or
that,
position of law,
my lord,
position of law, not
that 33 or protected workmen,
interpretation,
my lord.
basically. That protection. And okay, this has to be examined whether the register, which you are will be relying on judgments,
I'll be relying on.
revocation, whether that
I'll be
is-
relying on, my lord. I'll give the citation, my lord. I've got a printout also. 2006-11 SCC, page 731.
Lick it with you. Lick it with you.
I've given a copy, my lord. 37, my lord, at page 750.
Para 37.
Para 37 and 38. Here it was a case of a writ of quo warranto. Union had challenged the appointment of a person, my lord, a writ of quo warranto was sought for. There, my lord, in those circumstances, my para 37. We shall now advert to the provisions of the Industrial Disputes Act. Lordship has got it. Page 750.
Yes.
We shall now advert to the provisions of the Industrial Disputes Act with reference to the registration of trade unions. Section 2QQ defines trade union, which means a trade union registered under the Trade Unions Act 1926. Section 36 of the Industrial Disputes Act says that a workman who is party to a dispute shall be entitled to be represented in any proceeding under this act by any member of the executive or other office bearer of a registered trade union, of which he is a member, or any member of the executive or other office bearer of a federation of trade unions, to which the trade union referred to in clause A is affiliated. The writ petitioner union made a false averment that it is a registered trade union, and that itself, in our opinion, is a ground to dismiss the writ petition. The writ petitioner has made an averment to the following effect in his writ petition, which is also reflected in the order passed by the High Court in the writ petition, which runs thus. I'm not reading that, my lord. Coming to para 38. In the writ petition filed by respondents 1 and 2, their locus standi to challenge the appointment of the appellant was asserted in the following words. I'm not reading the quotation. These averments were established to be false. The registration of the first respondent under the Trade Unions Act had been cancelled as early as on 2/11/1992. It is not a registered and recognized union. In fact, it was pointed out that one recognized association in the so-and-so office and employees association, and the first respondent does not even have a handful of members. The fact of cancellation of registration of the first respondent came to the knowledge of the appellant long after the disposal of the earlier writ petition number so-and-so, wherein the court had given a finding that the first respondent had locus standi to challenge the appointment of the appellant to the post of managing director of the board solely on the ground that it is a registered trade union. In our opinion, the High Court gravely erred in refusing to examine the question of locus standi on the ground that it decided in the earlier writ petition, which operates as res judicata, and that the provisions even otherwise have petitioners even otherwise have locus standi. Chapter 3 of the Trade Unions Act sets out rights and liabilities of a registered trade union. Under the said enactment, an unregistered trade union or a trade union whose registration has been cancelled has no manner of right whatsoever. Even the rights available under the ID Act have been limited only to those trade unions which are registered under the Trade Unions Act by insertion of 2QQ in the ID Act with effect from 21/8/84, defining a trade union to mean a trade union registered under the Trade Unions Act. So even to be entitled to the protection, because the protection comes under the 33, to be entitled to protection, you have to be a registered trade union. And those Bombay High Court judgments, I'm just handing over a copy, my lord. Two judgments. One is 1987 SCC Bombay Online 492, para 5, my lord. It is the division bench, my lord. SK Desai and RL Agarwal. SCC online printout, my lord. Para 5. The case before us is a case where there was default committed by the union in carrying out its statutory obligations, and where, despite notice sent at the duly registered office, the union had failed to comply with the requisition made by the registrar. In the circumstances as provided by the statutory provisions, the registration of the trade union was cancelled as it was liable to be cancelled. We do not find in the statutory provisions any provision for revocation or withdrawal of such cancellation. Instead, there is a statutory right of appeal against the order of cancellation conferred under sections 11 of the said Act, which I have just now read, madam. The short question to be considered is whether, if the default is subsequently complied with, the registrar, by reason of said fact, has any inherent authority or power to revoke or review his earlier order of cancellation or withdraw the same. In the absence of any statutory provision in this behalf, the answer must be clearly in the negative, and the only remedy of the union, strictly speaking, is either to go in appeal from the order of cancellation or apply for re-registration.
Yes.
Similar is the view in the single judge, single bench order also, my lord. I'm not reading it, I'm just giving the paragraph, my lord.
21.
This one, my lord.
21. 21.
Paragraph, yes. When to sum up, the registrar cancels or withdraws the registration of a trade union, it has the option to appeal. If the appeal succeeds, so and so. And regarding the espousal, my lord, 75 4 SCC 838, discerning it. We had
Yeah,
brought up-
something is there.
Yes,
75.
yes,
Yes.
para 8. This, my lord, I'm taking it a step further. Suppose I lose on the ground of the union being an invalid union.
Hmm.
Whether the SPUs, because admittedly there were only 4 members,
Where from you're saying 4 members?
4 or 5 members, my lord, that is my pleading.
Those are factual things we do not do.
My lord, it
We
is
go by
not-
admitted things. Okay,
Because as of now, the union is not valid. There is no union. my lord.
so basically that power, there is no power for revocation.
There is no power.
So that 59, page 59 order is.
According
Okay,
to my
Mr.
respectful submission,
Gogoi, substantially hard, we can dictate the order only next day. If you want to add something which Mr. Decca has submitted. you
my lord,
can
only
add that.
thing that whether the protected workman thing that,
Just
let me,
just have a look whether that thing is exist or not. And what about this, why he has not appeared anything? This man,
it was upon, huh?
My lord, I have just checked, my lord, in some, normally the transfer policies contain such a provision.
right,
Now, whether
This
in
is
the
a
facts
private-
of this case,
this is private body,
Private body.
this is private.
normally I've seen, my lord. as far
Yes.
as-
I mean, if,
For public sector undertaking, it is
Yes.
that
clear.
will be different, man.
No, there are provisions for permitting also, then sufficient time must be given so
Right,
that
right.
union can make
And
arrangements.
because if he is industrial workman, they have different kind of
Different.
protection, even if it
I
is
think then
private
it
sector.
has to be governed by either by the
This,
act or the industrial
Yes.
standing order, my lord.
Because if we search Google, my lord, what is a protected workman, it goes to 33 of the Industrial Disputes Act. So let me make a research, my lord, I'll come back
just
to it.
so that it should not be in ignorance of any
Yes,
statutory
sir.
provision. Only that much. So many beneficial legislations are there.
Yes.
So it must not be in ignorance of certain
Because my lord,
statutory provisions.
if your lordship sees the trend also, initially it was interpreted in favor of the workman. 70s, 80s, 90s. Now slowly the interpretation is changing.
I have just started being conversant with this labor law.
I'll
That is
come
why
back-
I am a bit slow in that going.
No, my lord, we have to look into the law, my lord. Lordship
Okay,
will fix-
nothing much is left.
Nothing much is
Mr.
left.
Gogoi.
Only that part, Lordship will.
Lordship will fix
We
it on
can try.
Tuesday, my lord.
Tuesday, I have fixed that other one for petition, the other labor case. Just
So
hard.
that item number 1.
I think এইটো কৰিছ ন? এইটো কোনদিনা কৰিলো? এই ভৰসাই দি আৰু ৰয়টো। এই যে 1 নম্বৰ আইটেমটো।
Thursday.
চাওঁ এখন কিমান আছে?
No, I was hearing the interaction in item number 1, my lord, if I am permitted, my lord. Lordship may kindly, I have done some research in the lunch break, my lord. 1983 4 SCC 491 may kindly be looked into, my lord. Shambhunath Goel.
But Delhi cloth mill is clear.
That
If
Shambhunath,
it is holding the field. I do not know. That is why I have to check up that whether Delhi principles.
my lord, I'll give a list of 4 judgments I have written here, my lord.
19.
First is 1973 1 SCC page 813.
73,
1 SCC 813, that is Firestone. That I think is the beginning, my lord. Then 83 4 SCC 491.
4 SSC.
491. Then 2001 5 SCC 433. And the latest one is 2022 3 SCC 190.
2020.
22 3 SCC 190. Which says, my lord, even if you find that the inquiry is not proper, you can lead evidence.
290.
You can lead evidence on merits.
290.
190.
But that principle is clear. Delhi Lockmill.
Yes,
That if the labor court first has to see whether domestic inquiry is correct.
fair or not.
Fair or not, with reasonable opportunity of.
If it is fair, then quantum of
Because
punishment.
here is the case that charges have been framed, they were duly put on notice, they participated, submitted written statement. Both the sides laid evidence and inquiry officer submitted a report. But without any observation about that proceeding, the court has proceeded.
No, no, he
So
has
that
to
is
look
whether correct or not. That is the only issue.
That he has to look in.
Okay, I heard Mr. N. Dekal and I counsel for the petitioner and Mr. K. Gogoi, you represent whom?
He represent one, my lord.
And what about this man
He has not appeared, my lord.
Paper publication.
after service?
After service, paper publication was made.
Publication was.
Well, he's working actually. He's working somewhere, I know that, but lordship may not record that.
Mr. K. Gogoi learned.
Lordship, I am for one.
One and two.
One and two, Lordship.
3 has been struck off.
You
my
as
lord.
a CGC or state council?
State council, Lordship,
Okay.
state council.
Additional senior government advocate Assam for the respondent number
One and. two,
1,
Lordship.
2,
And 2.
1 and 2. Full stop. The respondent number 5 is learned counsel for the party. Notice for his appearance was published in a substituted manner in Ohomia Protein, in its issue dated 26/4/2019. Despite such publication, and respondent number 5 has not appeared in the case, on the next date of listing, in the event the respondent number 5 does not appear, the court will proceed with the matter accordingly. Yes, Mr. Dekka and Gogoi, when can be done? Not
Tuesday, my lord.
Tuesday, not possible. On other matters. Maybe some other day.
On fourth, Lordship.
Oh,
4th is a holiday, I think.
court is holiday.
4th is holiday. 4th, 5th, 6th holiday.
The fourth, fifth, sixth.
Seventh, already there. 11th?
Lordship, on
Oh,
11.
12, 12.
12th.
12. Lordship.
12 will. 12. 12, 9.
12. wait.
Only that much.
Lordship, Lordship,
Nothing is more to be hard.
Lordship, Lordship.
I think I cannot.
Yes, Mr. Chaudhary, you are waiting for what?
Attempt number 2, my lord.
It take much time because one matter which I recorded
My lord,
item 20.
my lord, half an hour, my matter cannot be concluded.
No adjournment will be granted.
Okay,
There is clear order
okay,
and order of deposit.
Hmm.
He had deposited the money, he said.
my lord,
This will take some time perhaps.
yes, yes. Take some time.
Because you missed the bus
Yes,
and they got started.
correct, man. In fact, I was also waiting in the first cab also. Somehow there was some miscommunication, my lord. Can it be on my lord? Ideally, it will be on the Tuesday or a Thursday, my lord.
Okay, yeah, that will be done. 14 then.
14th, my lord. Yes,
14.
Hmm.
14, yes.
1 second. my lord.
September. Because
Yes,
there
yes,
are many holidays in between.
yes, yes. 14th, my lord.
14. Thursday.
14th?
Okay.
K. Chaudhary, Senior Counsel, listed by N. Gautam. Petitioner, M. Sharma. Respondent,
I
IOC. You will list the case. 14.
My lord, there's one more matter, item 6 and 7, a little later than my lord 14th, my lord.
Okay, 18,
My lord,
then we'll proceed if
Fine.
required on a hearing. then.
Fine.
18.
deep level. 6 and 7. huh?
6 and 7. 18 or লিখে দিব বাকি অর্ডার মধ্যে সাইড দিম। Yes, Mr. Mojumdar. No adjournment.
Lordship, in this case, Lordship, no adjournment, but respondent number 2 and 3 has to be noticed, Lordship. The municipal board, Bongaigaon Municipal Board has to appear, Lordship, because they have filed an affidavit, I've checked up.
Oh, it's no more.
My.
So
Respondent
first, Mr. Bojumle has to satisfy me.
Yes, yes.
Itu নহয়. Are you sure you have paid the money?
I am showing. my-
Because there is an office note.
No.
It's
there
paid,
is no
Lordship. There
official-
was, I am paid, Lordship. I have seen, I have
Paid.
checked the paid. You paid, Lordship. I have checked up. There is a note from
Again note.
Lordship. That,
Okay. Okay.
I have seen, Lordship, I am appearing for 1 and 2, Lordship. 1, 2 and 3. 4 and 5 is required. They have
Their case is simple.
filed, Lordship.
Now, whether they are sustainable, we'll go by the affidavit.
Lordship.
Yes. Well, then,
Where is the tender notice? Page 20, come to page 20.
Page 20, madam, page 20,
It is- Yeah, it is good.
page 20.
Page 20,
Yes, Lord.
as simple as that.
Well, Lord,
Read.
Paramil, yes, close.
Page close to, two.
No,
Clause 2.
what I, even at the very outset, madam, what I'm trying to say. That the withdrawal of the tender, before it was accepted by the respondents.
Hmm?
Before it was accepted by the respondent. Then whether the earnest money deposited by the petitioner can be forfeited or no. That is the only question one needs to decide, madam. Here in this case, madam. Because my law is very much settled, madam. Section 5 of the contract Act is very much clear. Madam. That petitioner can withdraw its tender at any time before it was accepted.
Absolutely, no dispute to the said proposition.
Yeah.
Hey, tablet permission. No dispute to the said proposition,
Yes.
but what cost he will. He will incur. That is the issue only.
What is million?
Whether he will incur any. Loss for that.
No, they have not claimed anything, madam. There is no grievance, they have not raised any compensation or what is damage or anything, madam. They have not raised anything. They have not said so.
Now, what is the situation here?
Yes. Madam, petitioner, madam, withdrawn their tender and they are called into office of the respondent. Madam. They find it difficult to settle the market with the petitioners. Madam. That's
Come to
why,
page 3 then,
madam,
come to page 35.
35, madam. Yes, page 35, madam. Annexure 3. Particularly, you submitted tender only one even for a year. So in reference to the above, it is found that both of you have made the tender rate on same amount, which is found as the highest bidding amount as such. Both of you are requested to attend this office on tomorrow, that is so and so, to take the final decision for settlement of the market as per provisions of the municipal rules. Madam. So they visited their office. Madam. Then the resolution was taken, madam. You lordship may kindly see the affidavit in opposition filed by the respondent number 5.
Resolution, no, your page 36. First, you read your own letter.
No,
Your own letter.
yes, I want to, I returned to withdraw my offer, my lord, offers, my lord. Before it is accepted, my lord. You lordship, my lord, you said lordship may kindly see page 23 of their affidavit in opposition, my
No, please read first 36.
lord. 36. 36. To the Vice Chairman and the Municipal Chairman, with due respect, we have the honor to state that we, the undersigned, submitted tenders for settlement of the Chennai daily market for the year so and so. We come to know that the problem has arisen for quoting the same rate by all the highest bidding amount. It is therefore requested that we are ready to withdraw our tenders if the honest money that was deposited along with the tenders is returned by the authority concerned. And at the same time, we are very much sorry for our inadvertent mistake and also committed to extend our helping hand towards all kinds of cooperation in the near future.
Oh, you withdraw it.
They find it difficult, man, to,
After, no, they have asked you to come.
yeah,
Ah,
yeah, on the same day, they took a resolution, man, on the 19th. You
so
lost page 23, you lost me.
come to page 38 then.
Page 38, madam.
Hmm.
Withdrawal of tender, market for the year, so and so, so. Sir, with reference to the above, I am here to inform you that the subject to the following conditions, the board has decided to consider your application for withdrawal of the tender. Your honest money will be released only after the acceptance and realization of the fixed money from the Gangabala Chaudhary second highest bidder, madam, and if you are co-guarantor of the same. So second highest bidder, the payment of receipt from the second highest bidder, his money will be released, madam. But there is no such standards, terms and conditions like this, my lord, in the original NIT, my lord. In the event of failure by the second.
So you want to say about section 5,
Yes,
is it not?
of contract act, my lord.
Huh.
Section 5, my lord.
Ah.
And my lord,
Contract act.
only one point. Page 23, your affidavit of opposition, you what you may kindly say of response number 5, my lord. Their difficulty was, they expressed my in the resolution, my lord. Page 23, Annex 3. Page 24, my lord, resolution 3, my lord.
Yes.
Alright. In today's meeting, the vice chairman informed as regards the submission of tenders by the two tenderers, each in Chirra daily market and Chirra weekly market for the year so and so. Both the tenders have submitted 36 lakh each and 25 lakhs, my lord, respectively for the markets, and same as caused difficulties in settlement of the said market, my lord. That is the submission.
That is
Then
different thing.
the tenderers of the said market have also submitted two applications before the vice chairman, and the same was also read out in the application. 5 bidders of Chillara weekly market, namely Utpal Chaudhary and Subhash Chandra Rao, informed that they are willing to withdraw the tender subject to refund of the honest money amount. On the other hand, in respect of Chillara daily market, the highest bidder Sri Utpal Kumar Chaudhary and Sadhana Barman Chaudhary also submitted same request and expressed their willingness to withdraw from the tender process. In the meeting, the issue was discussed in detail. After considering all aspects of the matter and also considering the revenue of the municipal board, the meeting resolved that the highest bidders of Chillara daily market, Utpal Kumar Chaudhary and Sadhana Barman Chaudhary, may be allowed to withdraw their tenders if the second highest bidder, that is Srimati Gangabala Chaudhary, exert the settle market and deposit the money. That's it. So the said both bidders and other guarantors. So they find it.
So no decision is taken about the refund of security amount.
Now, decision taken, subject to the condition.
Allowed to withdraw.
Subject to the condition.
No. In the meeting discussed in detail, page 24. Where is the subject to the condition?
That they would be allowed.
They will be allowed.
They would be allowed, subject to the condition that if the money is received for the bid money from the second highest bidder, my lord. There is no such clause in that tender notice, my lord. Section 5, my lord, you contacted Lordship mechanism.
26. Vernacular. Nivida Mulya Grihita Vivesita Hoa Kunu Nivida Tatai Mohol Luat Ohonmoti Prakash Koile Tera Amanator Hon Bazyapta Para Hobo. As clear as crystal clear as water.
Section 5, my lord, Lordship mechanism.
You want to refer to section 5?
Section 5, contacted, my lord. What said, my lord?
That is what?
A revocation of proposals and acceptance.
1 minute. Yes, I. Section 5.
Section 5. May I read minutes?
Huh.
Okay. Let a proposal may be revoked at any time before the communication of its acceptance is complete. They have not accepted, my lord. It is very much clear from their letter also. They have been allowed to withdraw the tenders, my lord, the petitioners, my lord, before it was accepted, my lord. So my submission, and there are citations, my lord, before this honorable court, my lord. I'm citing 3 citations, my lord. Or 3
High Court.
High Court. High Court.
I am asking you about Supreme Court.
Supreme Court also, yes, reference was made to Supreme.
2000, no. Come to the directly to the Supreme Court, 2003, 7 SCC 410. Famous case.
2000.
That there is no term. The Indian Contract Act merely provides that a person can withdraw his offer before its acceptance. But withdrawal of an offer before it is accepted is completely different aspect from forfeiture of earnest money,
Yes.
which has been given for a particular purpose. A person may have a right to withdraw his offer, but if he has made his offer on a condition that some earnest money will be forfeited for not entering into contract, or if some act is not performed, then even though he may have a right to withdraw his offer, he has no right to claim that earnest money or security money be returned to him. Forfeiture of such earnest in no way affects the statutory right under the Indian Contract Act.
2000, my lord, 2000.
No, give me your citation.
Oh, yes. ma'am.
Because you are giving your citation, you are
Yes, yes,
relying,
yes,
you have no time.
Yes, my lord, I am sorry.
We have to dictate by 4:30.
First one is AIR 1991 Guwahati line, my lord. Paragraph 10 and 12.
None of these has referred to the Supreme Court judgment.
Yes, my lord, your lordship may kindly see.
Ronak, Rani, Datta Associate, Bridge and Roof, Tata, Mahabir, KP, Kirloskar, all these are on different points.
Supreme Court, my lord.
This 2002 GLR 55, about 12, 13 judgments have been referred, but none of these on the artist money.
So, well, 2002 GLR judgment, my lord, paragraph 12, my lord, Supreme Court has said, my lord, paragraph 12, my lord, that's the fact. Paragraph 12, my lord. This 2002 GLR case, my lord, is similar, and the facts of the, so far the facts of the petitioner is concerned. They're similar facts, man. That is Bombay High Court case also, well, Madhya Pradesh High Court case also, division bench also held the same thing, my lord.
You are challenging which one? Page 38.
Yes, my lord, page 38.
You both are husband and wife.
Both the husband and wife.
You bid for the same market.
Yes.
Full collision. Full collision.
The respondent. my lord,
Same bid,
Same amount.
value, husband and wife
Yes, lordship.
bidding for the same market.
Yes, sir.
Absolute collision. There is no other inference required to be drawn.
Well, there is no
With a
allegation.
pure intention
No, my lord,
to create confusion on the
No,
part of the.
on the basis of
settling
assumption,
authority.
my lord, the assumption.
Now I have, that law will not be applicable with a collision.
My lord, collision. my lord,
Husband and wife,
Yes,
right? Am I sure?
husband, wife,
Hus-
everything, my lord, husband, wife.
Husband and wife,
Yes,
both bidding for
yes,
one market
one market,
with same bid value.
will value. So what is the
What
duty,
is?
what is the duty of the respondent?
So both were called.
They could choose.
Both
one of
were
the-
called, mister. Then why not 50,000 more?
They could choose. one
Why
of
not
them.
50,000 cost more? This is absolute abuse of the process of the court. Both husband and wife bidding for the same market and with same bid value, 1 lakh. And you have taken another tender process for a ride.
Your lordship has taken.
More, 10,000 more.
Without any.
Hard.
my lord.
No. Now I have realized for both bidding for the same market, husband and wife,
So respondent
staying
could-
inside the
could-
same room
could- no, no,
for the
respondent-
same
no, no,
market.
I am submitting. Hold on, my
Hard,
submission
Mr.
is to be accorded, my
T.V.
lord.
Majumdar.
One of the respondent could have selected one, my lord.
Hard,
I told the
Mr.
truth,
T.V.
my lord.
Majumdar. hard.
There would not have any problem, my lord.
Okay, I have had enough. This is too much.
My
You have
submission-
taken everybody for a ride.
My submission may be recorded, my lord, and my submission, my lord, I stated, my lord. The solutions, my lord, law is settled, my lord. They can
I
withdraw,
will
my
say
lord.
that you
They can
have
withdraw, my lord.
admitted that both
Even
are
if it was
husband and wife.
accepted, my lord, they can withdraw, my lord.
We don't know. Enough is enough. Now I have realized that these two husband and wives staying in the same room, bidding for a one market with
They-
same price value
They are,
and taking the tendering authority for a ride. Are you a previously see?
yes.
Ah, see,
No, I'm running
See,
the market for since long.
my
my lord.
doubts are cleared.
Since long.
So they create confusion, they go on running the market.
Well, there are no such allegations, my lord.
Ah,
There are no such allegations.
where have you stated?
What is this?
Where have you stated? Where have you stated? Have you stated that you were previously see?
No, I have not stated, my lord.
Ah, that is has
I have
come
not
out.
stated, my lord.
But
have
I
not stated.
guess
I have no
correctly.
need, my lord, to mention this, all these.
I
things,
could
my
guess correctly
lord. I no need to mention, my lord, these things, my lord.
that
No need to mention.
Mr. Majumdar,
Your lordship,
this is
your lordship.
too much.
Is, I am, there is, my lord, is,
The,
Lloyd settled, my lord.
yes, Mr. I have had enough.
Yes, lord.
I have restored the writ petition
Lord.
after 5 years of delay. Only because you said that your mother expired.
Yes.
I have no sympathy to these two petitions. Just because you have filed a restoration petition
Yes, lordship.
saying that your mother was ill,
It is my duty.
so I restored the writ petition after 5 years.
It is my duty, my lord.
No, you have said, so I have accepted your position. I had no sympathy, right?
As for law, your lordship, my lord,
Thank
because of this case, my lord, I have no objection, my lord. Your lordship also, my position, your lordship also look at it. my lord.
I had. I thought that because of your others, the petition for it's for notification, I restored it. Right? Now things have come out in this. That whenever bidding for the same market, putting the same bid, what the municipal board will do?
They express the difficulties
No.
to settle the market. They expressly state, my lord.
Stop. I have asked you to stop. Two petitioners have joined together to institute the instant writ petition under Article 226 of the Constitution of India, stating that they are espousing a common cause of action. Full stop. They have assailed a decision taken by the respondent. Others may go, I don't think it will be possible. You don't have to wait because I have to declare this. Respondent Bongaigaon Municipal Board authorities, which had been conveyed to the petitioner by a letter dated 19/3/2013. Full stop. By the letter dated 19/3/2013, the petitioners were informed that their application for withdrawal of their bids were accepted. Would be upset or accepted. Subject to the condition that the earnest money would be released only after acceptance and realization of the first kiss money from the second highest bidder. Since both there is another one. Yes. Yes.
And she also backed up. She also backed up.
Since both of them were the co-guarantors of the second highest bidder. Better. Please take your seat. By tender notice dated 15/2/2013, the respondent municipal Respondent Municipal Board, Bongaigaon Municipal Board invited bids for settlement of a number of markets within its territorial jurisdiction. Situated number of markets and malls situated within the respondent municipal board areas for the year 2013-2014. Full stop. One of the markets for which bids were invited was Silarai Daily Market. Within bracket, except on Tuesday and Friday. Yeah, along with Milk Mahal, within bracket, quote unquote, the market for salt. Full stop. The responding to the tender notice dated 15/2/2013, comma, the two petitioners herein submitted their bids, comma, conspicuously, comma, quoting the same bid value at rupees 36 lakhs. Full stop. After the last date of submission of bids, comma, the respondent municipal board authorities opened the bids received in response to the tender notice dated 15/2/2013. Full stop. On opening and upon scrutinization of the bids, comma, it emerged that both the petitioners quoted the highest bid value at rupees 36 lakh each for the market. Mr. Roy, it is interesting that cost title, so and so, son of so and so,
Has not.
and petitioner,
Two.
daughter of so and so.
So and so, not have.
Very interesting. Next paragraph. The respondent municipal board issued a letter dated 15/3/2013 to the two petitioners herein, requesting them to attend the office of the respondent municipal board on 16/3/2013 to take a final decision regarding settlement of the market under the provisions of the Assam Municipal Act 1956. As both of them had quoted the same bid value in respect of the market. Full stop. By a letter dated (19/3/2013), comma, written jointly by the two petitioners, comma, the petitioners by written jointly by the two petitioners to the respondent municipal board, comma, the petitioners wrote to the effect that they could come to know that a problem had arisen for quoting the same bid value by the two of them as the highest bid value. Full stop. It was informed to the respondent municipal board that the two petitioners were ready to withdraw their tenders if the earnest money they had deposited along with the tenders, comma, earnest money deposits were returned to them. Full stop. In response to the letter dated 19/3/2013 of the petitioners, comma, the respondent municipal board wrote to them on 19/3/2013 itself that the respondent municipal board would accept their application for withdrawal of the tenders subject to the condition that the earnest money deposits would be released only after acceptance and realization of the first kiss money from the second highest bidder where the two petitioners were incidentally the co-guarantors of the second highest bidder, PIZ, Srimoti Ganga Bala Chaudhary. Full stop. The respondent municipal board, by another letter dated 19/3/2013, informed the second highest bidder that the market had been settled at her quoted bid value at rupees 30 lakh 50,000 and requested the second highest bidder to deposit 50% of the bid value within 21/3/2013. Stop. After receipt of the letter dated 19/3/2013, the second highest bidder by a letter dated 21/3/2013, comma, requested the respondent municipal board to extend the time period to deposit 50% of the bid value by 5 days. Full stop. Even after granting extension of the time period by 5 days to deposit 5% of the bid value, comma, the offer of settlement was not accepted by the second highest bidder and the said bidder did not deposit the amount. Full stop. Thereafter, the third highest bidder was offered the settlement, but he also expressed his inability to accept the offer Full stop. As a result of the purported refusal by the two joint highest bidders, that is the petitioners, followed by subsequent refusals to accept the offer of market. Refusals to accept the offer of settlement by the second highest bidder and the third highest bidder respectively, the market in question could not be settled with any of the bidders. Full stop. The municipal board had thereafter, took a resolution in its meeting held on 30/03/2013 to forfeit the earnest money deposits of the petitioners, submitted by them along with their bids, and to issue a fresh tender notice. Accordingly, a fresh tender notice was issued on 1/4/2013, and the market had to be settled by the respondent municipal board with the highest bidder in the subsequent process at a much lesser bid value of rupees 12. Full stop. Mr. P.V. Majumdar, learned counsel for the petitioners, and Mr. S.S. Roy, learned 1, 2, and 3 junior government advocate Assam for the state respondents. Full stop. Mr. Majumdar has referred to the provisions of Section 3(5) of the Indian Contract Act, and three decisions he has contended that a proposal may be revoked at any time before the communication of its acceptance is complete, as against the proposer, but not afterwards. Mr. Roy has drawn attention to clause 2 of the tender condition, 2 of the tender notice, to buttress his point that once the tender was accepted, the bid, the earnest money deposit made by such a bidder would entail forfeiture if such bidder at a later point of time expressed inability to accept the offer. Full stop. The condition has the said condition had made it clear that in the event of such withdrawal by the bidder, the municipal board authorities would be at liberty to get it recompense from such a bidder. I have considered the submissions of the learned counsel for the parties and have also gone through the materials on record. Full stop. When a query is made to the learned counsel for the parties as regards preferring the two repetitions, preferring the repetition by the two repetitioners jointly, comma, it has come to the notice, the learned counsel for the petitioners has admitted that the two petitioners are husband and wife by relation. Full stop. A look at the addresses of the petitioners, that is Ward number 5, Bongaigaon, Post Office, Police Station, District Bongaigaon, PIN 783380, also goes to indicate that they are from the same locality. Full stop. On a further query, learned counsel for the petitioners has permitted that as everybody is hand in gloves. And they come to the court. Both of them were previous leases or one of them?
One of them.
One of the two petitioners was previous lessee of the market. Full stop. It is quite clear from the aforesaid facts that quoting of the same bid value by the two petitioners who are husband and wife, comma, for the same market was not a coincidence. And the act of quoting the same bid value was on the face of it was an deliberate act. এটা কেছত যে 25,000 টকাতে কৈছিল কেডি শৰ্মা আৰু কিবা কিবি সাইটেশন দিয়া আছে who doesn't enter pleadings the court, no, the pleadings in the writ petition, there is no whisper in the pleadings of the writ petition that the two petitioners are husband and wife by relation. And one of them was the previous lessee of the same market. Full stop. The fact that they are also co-guarantors of the second highest bidder is also cannot be also termed as a mere coincidence. Full stop. Clause 8. Dr. K.D. Sharma লিখে দেব। এটা নহয় clause. Clause 8 of the tender notice had stipulated that once the bid value was accepted and the selected bidder express his disinclination to accept the offer, comma, then the earnest money of such a bidder was liable to be forfeited, and the offer of settlement for the market was to be given to the next higher bidder. Full stop. It was further stipulated that in the event of such refusal, the municipal board had to suffer loss, then the entire loss amount was liable to be recovered. The municipal board would be at liberty to recover the entire loss from the bidder who had disinclined to, who had refused to accept the offer. Full stop. In the case in hand, comma, as has been mentioned earlier, it needs in the case in hand, comma, it needs reiteration, comma, even at the cost of repetition, comma, that when after refusal of the two petitioners, that is the husband and the wife, comma, to accept the offer of settlement, the municipal board offered made the offer of settlement to the second highest bidder. The second highest bidder also refused to accept the offer of settlement. Thereafter, comma, the third highest bidder was offered the settlement, but he also expressed his refusal to accept the offer of settlement. Full stop. As a result of refusal to accept the offer of settlement by the two joint highest bidders, that is the petitioner, two petitioners, followed by subsequent refusals to accept the offer of settlement by the second highest bidder and the third highest bidder respectively, the municipal board could not settle the market in question with any of the bidders despite undertaking a bidding process by publication of a tender notice. Full stop. The municipal board had thereafter required to take a resolution in its meeting held on 30/3/2013 to forfeit the earnest money deposits of the petitioner and to issue a fresh tender notice. Full stop. Accordingly, a fresh tender notice was issued on 1/4/2013, and the market had to be settled by the respondent municipal board with the highest bidder in the subsequent bidding process at a much lesser value of rupees 12 lakhs. Full stop. Thus, it is clear that because of the refusal to accept the offer of settlement by the two joint highest bidders who are husband and wife by relation, followed by refusals of the second highest bidder, where the two joint highest bidders were the co-guarantors, it is evident that in the absence of disclosure of such interrelationship, it is clear that the two petitioners have approached this court not with clean hands. Their hands their hands are found to be soiled. Dilip Sharma লিখে দিব। In National Highway Authority of India versus Ganga Enterprise and another, the Honorable Supreme Court of India No, sorry, the facts. Comma in brief, which fail for consideration in so and so versus so and so reported in so and so, where that the respondent therein gave his bid in response to the tender notice. Full stop. For collection of toll. Full stop. Along with a bid security. Full stop. When he repetition, he withdrew the bid security before acceptance of the offer. When a writ petition was filed before the High Court, sorry, the NHA authorities forfeited the bid security. First of, when a writ petition was preferred for refund of the amount, comma, the High Court considered as to whether High Court considered two questions, and one of them was whether the forfeiture of security deposit is without any authority of law and without any binding contract between the parties, and also contrary to Section 5 of the Contract Act. First. The High Court held that the offer was withdrawn before it was accepted, and thus, comma, no completed contract had come into existence. And it was always open to a party to withdraw its offer before its acceptance. The Supreme Court, the Honorable Supreme Court of India, had observed that the High Court should not have considered the said question first before considering a question of maintainability of a writ petition involving disputes relating to the contract in a writ petition under Article 226 of the Constitution of India. First of, the Supreme Court had, Honorable Supreme Court had observed that the High Court fell into error in observing as above, full stop. The it has been observed that the Indian Contract Act merely provides that a person can withdraw his offer before its acceptance. First stop. But withdrawal of an offer, comma, before it is accepted, comma, is a completely different aspect from forfeiture of earnest money, which has been given for a particular purpose. First stop. A person may have a right to withdraw his offer, but if he has made his offer on a condition that some earnest money will be forfeited for not entering into contract, or if some act is not performed, then even though he may have a right to withdraw the offer, comma, he has no right to claim that the earnest be returned to him. Full stop. Forfeiture of such earnest money, comma, in no way, comma, affects any statutory right under the Indian Contract Act. Full stop. Such earnest money is given and taken to ensure that a contract comes into existence. Full stop. It would be an anomalous situation that a person who, comma, by his own conduct, comma, precludes the coming into existence of the contract, is then given advantage or benefit of his own wrong by not allowing forfeiture. Full stop. It has been observed that in government contracts, comma, such a term is always included in order to ensure that only a genuine party makes a bid. Full stop. If such a term was not there, even a person who does not have the capacity or a person who has no intention of entering into the contract would make a bid. Full stop. The whole purpose of such a clause is to see that only genuine bids are received. The whole purpose of such a clause, that is, to see that only genuine bids are received, would be lost if forfeiture was not performed. The earnest money deposit deposit of earnest money was in essence an earnest to be given to ensure that the bidder did not withdraw his bid during the period of bid validity, and or that after acceptance, there are in so and so, there are two other decisions. A decision publicly, a decision is always so and so on the basis of the facts in hand. In such period of matter, the decision referred to by Mr. Majumdar are found to have no assistance to the cause of the two petitioners. In the light of the discussion made above and for the regions aside, I find no merit in this writ petition, and the same is liable to be dismissed. It is accordingly dismissed. There shall be no more investments. So not clean hands, and it is not Supreme Court decisions. But apparently my view is it is completely an abuse of the process of court. Husband and wife quoting for the same market with the same bid value, thereafter withdrawing it, thereafter in the bidder who quoted second, you had a
My lord,
co-guarantor, then you made to withdraw the second. Ultimately, you are previous facing. And the bid market is run by.
well, one
I
thing,
not say much, I have closed the.
well,
Before saying.
may I submit one thing, my lord? Actually, only for your lordships, observe, my lord, because there is citation, well, actually, I am not having right now, two petitioners quoted same price. One of them was selected. The other one, challenged this. Other was challenged.
Staying inside the same group. Putting the same.
Same
market for the same market is not a matter of coincidence. Mr. Roy and Mr. Gogoi quoting for Jalukbari market and coincidentally, at the same way, is a different thing. Husband and wife. Without disclosing this, that they are.
That husband and wife.
Putting the same way. From the residing from the same house. It's completely act of. Deliberation. And elapharing.